Madam, Geeta Devi, madam. Hello. Madam.
ಹಲೋ ಹೇಳಿ
Madam,
ಮೇಡಮ್.
madam, ಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದೆ ಒಂಚೂರು ಕೋರ್ಟಲ್ಲಿ 20 ಕಡೆ ಬರಕ್ಕಾಗುತ್ತಾ?
ಯಾಕೆ ಮ್ಯಾಮ್?
ಅಲ್ಲ ಬರಕ್ಕಾಗುತ್ತಾ? ಬಂದಿದ್ದೀರಾ ಕೋರ್ಟ್ಗೆ?
ಇಲ್ಲ ಮ್ಯಾಮ್, ಇವತ್ತು ಹುಷಾರಿಲ್ಲ, ಬಂದಿಲ್ಲ.
ಹೌದಾ, ನಿಮ್ ಜೂನಿಯರ್ ಯಾರನ್ನಾರು ಕಳಿಸ್ತೀರಾ?
ಇದಾರೆ ಅಲ್ಲೇ, ಇವತ್ತು ಒಂದು ಕೇಸ್ ಇದೆ, ಮೆನ್ಷನ್ ಮಾಡಕ್ಕಿದ್ದಾರೆ.
ಓಕೆ 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 ಮೇಡಮ್. ಓಕೆ.
ಅಲ್ಲೇ ಇದಾರೆ, ಮೆನ್ಷನ್ ಮಾಡಕ್ಕಿದ್ದಾರೆ ಮ್ಯಾಮ್.
ಓಕೆ ಓಕೆ ಮೇಡಮ್. ಓಕೆ.
ಏನಕ್ಕೆ ಮ್ಯಾಮ್?
ಏನಿಲ್ಲ, ಜೂನಿಯರ್ ಅಂತ ಕಳಿಸ್ತೀನಿ ಬಿಡಿ.
ಅಲ್ಲಿದ್ದಾರೆ ಅಲ್ಲಿ.
ಹಾ ಹಾ. ಇನ್ಯಾರು ಇಲ್ಲ. ನೆನ್ನೆ ಅದೇ ಅಂದೆ. ಇದು
submission. Serial number 15, I'm filing memo for withdrawal.
serial number 15.
Inspectors.
15, sir. 15.
15. Certificate on record is no more. The petitioner himself has signed the memo.
You are the defendant in the suit.
No, ma'am, petitioner.
G,
Yeah, in the suit I am, in the OS I am defendant.
That's what I'm saying. A memo
Okay,
is
sir,
filed
sorry.
stating that the suit is dismissed as abated. It's OS number 2379 of 2012. And the present memo is filed seeking withdrawal, stating that he may permitted to withdraw, reserving liberty to challenge the order if the original suit is reviewed, is revived. The memo is taken on record and the same is dismissed as withdrawn with the liberty to come up with an appropriate application in case the suit is revived. Yes.
26.
Yes.
Number 26.
Page-wise
Page-wise
adjournment.
adjournment. Page-wise adjournment, page 1, serial number 1 to 6. Page 2, serial number 7 to 9. Page 3, serial number 10 to 13. page 4, page 5, serial number 14, 16.
Serial number 16, my lords, filing a memo for withdrawal.
Take that.
Matter has been settled out of court.
It is submitted, the matter is settled out of the court, the memo is filed, seeking to withdraw the petition, accordingly memo is taken on record. The petition is dismissed as withdrawn. Yes,
Grateful.
Page number 6, serial number 17 to 20.
Serial number 18. Pray for 2 weeks to file necessary application.
Defense notice unserved.
why you want that much time, 2019 matter? A week's time, step shall be taken, a week's time for filing the application for substituted service, or else the petition shall stand dismissed without further reference to the court. Yes, next.
Page number 7, serial number 21 to 26,
Serial number 26, Lord, I am for the petition.
Serial number?
26, my lord.
24. Page number 24. Page number 8, serial number 25.
Yes, 26, what do you want?
2 weeks time. Senior is unwell, my lord. I take you. Have informed the other side.
At the request of non-counsel, the petitioner, this is matter on 11th of March,
My lord, 17 March. Please.
11th of March.
Page number 9, serial number
Millards.
30.
Millards with kind leave, Millards, number 27, Millards. I am appearing for respondent number 2. I have informed the petitioner, Millards. Matter is getting settled, Millards. If my lords can kindly grant us 2 weeks time, we'll report the settlement and
Submitted to the non-counsel respondent that the matter is going to be settled between the parties.
My lords.
This matter on 8th of April. Yes,
26.
Millards, the interim order may kindly be extended. There is an interim order in favor of petitioner.
order granted is extended.
Grateful.
Serial number 26, my lord.
Notified adjourned on 11th of March, my lord, on 12th of March.
12th of March, yes.
My lords, serial number 29, and for the petitioner, sincere apologies, I've misplaced the file, my lords. It is with the TCR. I'll apply it today, my lords. May I request for 2 weeks, my lords.
Who appears for the respondent?
Third,
Shankar Reddy appear.
C. Shankar
Informed
Reddy.
him?
I'll inform you.
No, I will. You should inform and come back. Yes, next.
Yes, my lord.
Serial number 35, my lord. I appear for the respondent 2 weeks time, my lord. Next week, my lord. Kindly have it next week.
Have you informed the other side?
No, my lord.
Wait till the matter is called. Yes.
Serial number 36. Senior is not feeling well.
30,
36.
inform the other
Yes,
side.
sir. Yes,
You are for the petitioner.
yes, sir.
At the request of the counsel for the petitioner. This is matter on 12th of March. Yes, next.
Page number 10, serial number 39 to 43. Page 1, part-time matter, serial number 1. Sagar BB for petitioner.
Yes,
BB
I am
ID.
appearing for petitioner, Your Lordship. I am filing a memo for withdrawal.
The petitioner, my lord, they are filing a memo for withdrawal of it.
What is this memo for withdrawal running into 2 pages?
My lord, just I will explain, my lord, why we are withdrawing the report. Parties have settled the dispute outside the court, my lord, so they don't want to press this petition.
ಕಾಪಿ ಇದೆಯಾ ನಿನ್ನೆ ಕೊಡ್ತೀನಿ
My lords,
ಇಲ್ಲ ಕೊಡ್ತೀನಿ ರೀ ನಾನು
You saw the memo?
my lords, I have some submission to make, my lords, in that.
That's why in the memo cannot be like this.
Yes, my lords, that is my
It can't be
submission.
like this. All these things this court cannot,
Please, my,
record. Just file a simple memo for withdrawal.
please.
That will be done. So many, it almost amounts to recording the reasons for that.
If you lordship
can't be
asked
done.
me, my lord, why you are withdrawing, that's why I thought to place it down.
It shouldn't be like that. Like, ask them, if you want to withdraw, it should be a
ಮಂಡೇ
simple
ಹಾಕಕ್ಕೆ
memo for withdrawal.
ಲಾರ್ಡ್ಶಿಪ್ ಮಂಡೇ
Huh?
ಮಂಡೇ
Monday.
Yes.
Well, you can write it and give,
ನೋ ಮೇಡಮ್ ವಿಲ್ ಪರ್ಫೆಕ್ಟ್
You want to secure parties presence.
ಪಾರ್ಟಿಸ್ ಪ್ರೆಸೆನ್ಸ್
let it be on Friday, not Monday. This is matter on Friday.
7.
Yes.
Great.
Serial number 2. BB
Milords, in this matter, in this matter, I appear for respondents, Milords. The senior is not keeping well, Milords. A week's time may be granted. He is suffering from chikungunya, Milords.
Wait.
Number 2, I thought.
It is submitted that the counsel for the respondent is unwell. This is matter on 11th of, on 5th of March.
5th of March.
Much obliged, Milords.
Delete from Parker. Yes, next three.
Serial number 3. R.B. Sadashivappa for petitioner, P.M. Sidmalappa for
Okay.
respondent.
Appear for respondent list. My lord, I'm filing a memo. With regard to the two application, common order was passed by the trial court, order 39 rule 1 and 2, and as well as section 94 CP. The 39 rule 1 and 2, they have challenged filing the miscellaneous appeal before the senior division, please lord. That miscellaneous appeal was dismissed and confirmed the interim order granted by the trial court in the same common order. Now he has challenged before this honorable court challenging the only application
94
94C.
Order passed under my lord common orders. One is under 39 1 and 2 and another under section 94 C and E of the CPC, my lord. The present writ petition is filed only with regard to the order passed under the 94 C and E of the CPC, my lord. As against, my lord, the granting of injunction, my lord, appeal has been filed, appeal dismissed. Now they had to file a writ petition before this honorable court.
When
my
was
lord.
it dismissed?
My lord,
The MEI is dismissed on
June
26
2024.
June 2024. Till to that, there is no writ petition filed.
My lord, so far as my lord, the suit, my lord, the present writ petition is by the defendant. Suit for the relief of declaration and for injunction, declaration regarding the easementary rights over the, to reach the property of the plaintiff, my lord. My lord, I would, first, my lord, I would like to take my lord attention to the schedule of the plaintiff. My lord, it is the summons.
Before that, please come to the impugned order.
Please, my lord.
Impugned order.
Impugned order, my lord, in page number 14.
Let's look at it first.
My lord, from para 6 onwards, my lord, it commences as these points are interlinked to taken together discussion. Further, the rival contention of both the parties already.
Now, how do you, IA number 1 is filed under order 39 rule 1 and 2.
IA number
Then
3.
I number 3 is filed under order
94 C
and so, restrain the defendant, so and so, putting up any construction or the
construction
property.
over the B schedule property.
So
My lord,
these are,
my lord.
according to you, 1 minute, according to you, these two are independent. When the court gives a finding that you are not entitled for injunction, then still you are entitled for a relief under 94.
Yep, my lord, my lord, I would like to make some submission. So far as, my lord, it is the specific contention of the plaintiff, my lord. B schedule property is the only way to reach the property of the plaintiff.
And injunction is sought in respect of what?
Injunction is granted, my lord, that is appeal filed, appeal dismissed.
No. I'm asking you, injunction is also in respect of B schedule property.
My lord, so
Please.
far as, my lord, 94 C and E, the relief sought not to put up construction over the, my lord, the B schedule property. B schedule property is the exclusive property of the defendant. It is
Now
the
let
property
us
of the
see,
defendant.
in this IA, that is under IA number 1, what is the finding of the court with regard to the B schedule property?
My lord, the common orders, my lord, the page number 17.
Read from the reasons.
My lord, the reasons, my lord, as these points are para 6 onwards, my lord, as these points are interlinked, taken together for discussion. Further, the rival contention of both the parties has already narrated about to avoid the repetition. The same has been considered here. It is the specific contention of the plaintiff that he is the absolute owner of the possession of the A schedule property and using the B schedule property as a pathway to reach his house without having any right title over the said B schedule property. The defendant obstructing the plaintiff to use the B schedule property and also attempting to put up construction over it. On the other hand, defendant submitted that there is no such pathway as stated in the B schedule property. The defendant has left a 9 feet passage in the written statement schedule property for the use of cattle shelter. On perusal of the entire material placed by both the parties, it is pertinent to note that OS 79 of 2002. Well, this is the suit filed by the defendant against the plaintiff for the relief of injunction. This suit dismissed for non-prosecution long back in the year 2002 itself. It has been observed that about existence of the 12 feet road. Further, in the present suit, there is a dispute with regarding the existence of the pathway towards the eastern side of the defendant property. That is the B schedule property. Moreover, the defendant submits that he has left the 9 feet passage for his domestic purpose. Accordingly, whether there is an existence of road or passage as contended by both the parties has to be decided only after the full-fledged trial by obtaining the necessary report. As observed, the previous suit, OS 79 of 2002, my lord, the prima facie, it appears about the existence of the 12 feet road towards the eastern side of the defendant property. The document adduced by the plaintiff reveals that at this stage, the plaintiff has made out a prima facie case. As such, if the injunction order is not granted, if the defendant is proceeded with the construction over the B schedule property, it may lead to multiplicity of the proceedings and also cause a hurdle to the plaintiff. On the other hand, if the defendant is the restrained from any construction in the schedule B property, no inconvenience would be caused. Therefore, I am of the considered opinion that the plaintiff has made out a prima facie case and balance of convenience tilts in his favor, and the injunction is refused, the plaintiff will be put to.
Yes, I've seen the order.
My lord, so far as my lord, allowing the application under IA number 3, that is filed under section 94 C and D of the CPC, my lord. Restraining the defendant to put up construction over the passage, that is the exclusively meant by the defendant in his written statement schedule property. Hence, my lord, I would like to take first, my lord, the schedule, my lord, the mention in the plaint as well as the schedule given in the written statement. My lord, the ink page number 22, the schedule mentioned in the plaint. My lord, this is the A schedule. It is the absolute, plaintiff is the absolute owner. It is not in dispute. My lord, I am not disputed in my written statement also. Kindly see the, my lord, the boundaries. East by 12 feet road. He has already mentioned east by 12 feet road. That is the common access by of the plaintiff to reach the main house from his house. Kindly see, my lord, north side, north by passage and house of the defendant. This, my lord, the B schedule property, my lord, he has given, my lord, the so far as the schedule to reach the house of the plaintiff. Kindly see the B schedule property also, all the part and parcel pathway having east to west 12 feet width and south to north 60 feet width. Illi, he is already an existence of the road towards the eastern side. Kindly see the schedule of the B schedule, western side house of the defendant, and northern side village main road. Next, my lord, I would like to take my lord attention to the.
So that the B schedule property, for what purpose you are using it?
My lord, it is my exclusive property, that the same is meant for my cattle shed. That is the increase and decrease to my cattle shed. 9 feet I have left for my personal use only.
So what is the order?
My lord,
Asked by the court.
the order, my lord, so far as, my lord, the trial court, my lord, having not taken into considered, my lord, the schedule. Merely, my lord, I filed the suit at the first instance in the.
What is by this order? What is that the
My
court
lord,
has
so,
directed you?
My lord, so far as, my lord, the section 94 C and E is made applicable to the supplementary proceedings. My lord, it has to be granted only unless there is a perversity of the order, my lord, the passed by the trial court, and it is made by the defendant. In this case, my lord, there is no such perversity of the order, my lord.
Look at the order. Let's look at the section. Yes.
The 94, my lord, the supplementary proceedings.
Yes.
In order to prevent the ends of justice from being defeated, the court may, if it is so prescribed, C and E, my lord, he has filed, grant a temporary injunction, and in case of disobedience, commit a person guilty thereof to the civil prison, and order that this property may be attached and sold. E, make such other interlocutory orders as may be appears to the court may be just and convenient. My lord, the impugned so far as, my lord, in the present case.
So why don't this order fall under 94E?
My lord, so far as, my lord, there is no such findings as such has been recorded by the trial court while passing the impugned order. And it is not
recorded. It
my
has
lord,
recorded.
it is not my lord, it is not a speaking order. Merely, my lord, at the first instance, I filed the suit for the relief of injunction in OS 79 of 2002. And there is an existence of the 12 feet road in the said suit. That suit is filed by me for the relief of injunction against the defendant, against the plaintiff. That suit dismissed for non-prosecution logback. Merely, my lord, the recitals of the, my lord, it is not made applicable to the present suit. And secondly, my lord, section 94, so far as, my lord, just now my lord referred, my lord, it is made applicable to supplementary proceedings, and it will be invoked only unless the defendant made out perversity. There is no such perversity of the order as such, my lord.
In order to prevent the ends of justice from being defeated, the court may, if it's so prescribed, make such orders. Where do you get that it has to be done only in supplementary proceedings?
Unless it is made out, the perversity
We are
has been.
looking at 94. Let us read the language as employed in the section.
make such other interlocutory order as may be appear to the court may be just and convenient. My lord, by virtue of the impugned order, my lord, the trial court restraining the defendant not to put up construction over his property. Over his property. Kindly see, my lord, the impugned order, my lord. This is the perversity, my lord. The defendant and his agents and henchmen, servants, or anybody acting on his behalf are hereby restrained.
Now,
by
the
way of-
whole dispute between both the parties is about the
Not-
suit B schedule. According to him, he is using it as a pathway.
ಏನಾಗಿದೆ?
According to the defendant, it is the defendant's exclusive property. What is the finding of the court? That whether he could make out a prima facie case, and if you make any construction in the B schedule property, if you put up any construction, his ingress and egress to the property would be effected. And in the interest of justice, court has passed an order. Now, with regard to making out a prima facie case and other things,
there is
an
no
appeal
such-
is filed,
Allah, there-
appeal is confirmed.
My lord, under the impugned order, my lord, there is no discussion so far as the prima facie case, balance of convenience and irreparable losses. My lord,
That
absolutely
any
there is
court
no-
will not look into it because all
that is why, my lord, I have not. My lord,
miscellaneous appeal
touched
is
on-
filed and it is confirmed.
And so
Yes.
this regard, my lord, I would like to cite, my lord, the.
Take that.
ruling of the Honor- I would like to take my lord attention to the take note, my lord.
Yes.
Order 39, rule 1 and 2, read with section 94C, and, section 151. The petition for injunction restraining the respondent from bringing the suit property to sale in execution.
You are
of
reading
next-
para number?
My lord, I am reading head note only. Then
Let's
I-
go to the paragraph.
My lord, then my lord, I would like to take my lord attention to para 11. The precondition for exercising the jurisdiction by the court, whether under order 39, rule 1 and 2, read with section 94C or under section 151, the petitioner has made out a strong prima facie case. The balance of convenience in his favor for granting an order thereunder. The power cannot be exercised by mere asking. If the court grants an order without recording its findings on these proceedings, the order would suffer from error of jurisdiction. In the instant case, the trial court did not go into the question as to whether the petitioner has made out a strong prima facie case to entitle him to an order under 39(1) and 2 CPC, read with section 94C CPC. Under section 151. Indeed, the court recorded that no order could be granted under 39(1), but proceeded to pass an order under 94C, read with section 151, on the ground that there is order 39 does not apply. Section 94C is attracted. Even if we assume that 94C is a mere mistake in quoting the provision of law and order is treated as having been made under section 151 CPC, the fact remains that the order revision does not satisfy the requirements of the valid order under section 151 CPC. Inasmuch as the court has to go into the question as to whether the petitioner has established a prima facie case and whether the balance of convenience lies in favor of the petitioner, we entitle him to get an order of injunction restraining the defendant from bringing the suit property for sale in execution of the decree. Here, what happened, my lord? The collusive decree has been obtained. Injunctions, my lord, the execution has been filed. My lord, the suit has been filed and application has been filed, that execution proceedings has been stayed. Merely, there also, my lord, there is no, my lord, the detailed order as such, my lord, has been passed by the trial court. Hence, the court observes, my lord, the court has to assign reasons. My lord, what perversity, my lord, has been done by the defendant? My lord, mere asking, mere granting the relief does not, it shall not be granted.
Please come. Agreed with the orders passed on I number 3. Filed under order 94C and E, read with 151 CPC, dated 10th July 2019. The defendant is before this court. The respondent herein had filed a suit seeking a declaration declaring that the plaintiff has got right of easement of prescription to use B schedule pathway to reach his residential house from main road for consequential relief of permanent injunction, restraining the defendant, his agents, his henchman, servant, or anybody acting on his behalf, obstructing the plaintiff from using the B schedule pathway to reach his residence house from main road in any manner. In the sets, in the suit, the plaintiff had come up with two applications, that is IA number 1 and IA number 3. IA number 1 is under Order 39, Rule 1 and 2 for grant of temporary injunction, restraining the defendant, obstructing the plaintiff from using the scheduled pathway to reach his residential house from main road. And further, I number 3 under Order 94C and E, read with 151 CPC, restraining the defendants from putting up any construction over the B scheduled property. The trial court, by order impugned, had allowed both the applications against an order granting injunction. That's IA number 1. The plaintiff the defendant had filed MA number 18 of 2019. That came to be dismissed by order dated 26th day of June 2024, confirming the orders passed by the trial court in IA number 1. Against the orders passed in IA number 3 under Order 94C and B, that with 151 CPC, the defendant is before this court. The court, while allowing the applications, had observed that it is a specific case of the plaintiff that is absolute owner of the plaintiff A scheduled property, and he has been using B scheduled property as pathway to reach his house without having any right title over the B scheduled property. The defendant is obstructing the plaintiff to use the same and also attempting to put up construction over it. According to the defendant, there is no pathway as stated in the B
In
schedule.
their written statement, they have mentioned, please, Lordship.
Huh?
In the written statement, they have specifically mentioned 9 feet pathway is there.
No, that is in the.
For
The
my
defendant has
property.
left 9 feet passage in the written statement scheduled property
I have
for the
stated.
use of the cattle shelter. The court further observes that OS number 79 of 2002 is filed by you. Mr. Counsel, is filed by you.
Yes, ma'am.
OS number
Yes, 79, yes,
uh,
ma'am.
79, which is filed by the
2002.
defendant seeking permanent injunction against the
Plaintiff.
suit that is filed.
Observe 12 feet passage with regard to their file.
That I can see here. OS number 79 of 2002 is filed by the petitioner herein, who is the defendant in the suit, against the respondent herein, who is the plaintiff in the suit. And it has been observed that existence of 12 feet road, further in the court observes that in the present suit, there is a dispute with regard to existence of pathway towards the eastern side of the defendant's property. Moreover, the defendant submits that he has left 9 feet passage for his domestic purpose. The court observes that whether there is an existence of road passage has to be decided only after a full-fledged trial by obtaining the necessary reports. As observed in the previous suit, prima facie it appears about the existence of 12 feet road towards the eastern side of the defendant's property. The document adduced by the plaintiff reveals that at this stage the plaintiff has made out a prima facie case. As such, if the injunction order is not granted and the defendant proceeds with the construction for the B scheduled property, it may lead to multiplicity of proceedings, also cause hurdle to the plaintiff. On the other hand, if the defendant is restrained from any construction in the suit scheduled B property, no inconvenience would be caused, and accordingly voted or allowed both the applications. Learned counsel appearing for the defendant submits that the court ought not to have passed any order invoking order under section 92, read with, and then section 94A, C and E, read with 151 CPC. It is submitted that there is no perversity which made the court to pass such an order. It is submitted that while the court ought to have recorded the reasons for granting the order, Land council submits that in the entire order, it is silent about the prima facie case, balance of convenience, and irreparable loss. Without even recording any reasons, just like that, for the sake of mere asking by the plaintiff, the court has granted the relief. He had relied on the judgment of the AP High Court in case of Madhuri Padmavati versus Chintala by reported in 1994 to ALT 477. He had relied on paragraph number
11.
paragraph number 11. He submits that in the light of the said order, the discretion that is exercised by the court and granting an order under section 94 of the act is contrary to the facts and as well to the law. And the order under revision needs to be, the order impugned needs to be set aside. Next para, learned counsel applying for the respondent plaintiff submits that it is a case of the plaintiff that he has been using the pathway to reach his house. The defendant also admits that there is a pathway and is using it to reach his cattle shed. Considering the earlier suit that is filed and the pleadings in the earlier suit, court has rightly observed that there is an existence of the pathway, and the petitioner is asked the plaintiff if the injunction is not granted, it would cause loss to the plaintiff. And if the defendant puts up any construction in the said pathway, it would cause a lot of hardship to the plaintiff, and no prejudice would be caused to the defendant, and rightly granted injunction. And also the application under 94 is allowed by restraining the defendants from putting up the construction. He submits that now the injunction that is granted by the court is confirmed by the appellate court in MA number
18/2019.
in MA number 18 of 2019 dated 26 June 2024, and no appeal is preferred against the said order. In those circumstances, the petitioner is not entitled for any relief from the court, and the writ petition is liable to be dismissed. Next para. Having heard the counsels on either side, produce the material on record. The two applications that are filed, one is under Order 39, Rule 1 and 2, and the other is under Section 94C and E, read with 151 CPC. As far as granting of injunction is concerned, this court, that is not impugned before this court, and the court has given a finding that the plaintiff is entitled for injunction, and again it's that the defendant has appealed, and the appeal is dismissed. So both the courts have concurrently held against the defendant and in favor of the plaintiff that he is entitled for injunction. The whole dispute in this case is about the Schedule B property, which is a pathway. The existence of the pathway is not disputed by any of the parties, but according to the defendant, it is his personal property and is using it to reach to his cattle shed. When the suit itself is with regard to the pathway and existence of the pathway is admitted, the court has come to the conclusion that it has to be decided whether there is a pathway that's used by the plaintiff or plaintiff has any right to that. the whole purpose of granting an interim injunction or any interlocutory order is to see that the interest of the party that has come to the court is protected. It is a contention of the land council that the court ought not to have passed an order under section 94 of the act, and he relied on the judgment of the AP High Court in case of Madhuri Padmavati referred to supra. The court in paragraph number 11, on which heavy reliance is placed by the land council of the petitioner, has observed that the preconditions for exercising jurisdiction by the court, whether under Order 39, Rule 1 and 2, read with Section 94C and under Section 151R, the petitioner has to make out a strong prima facie case, balance of convenience. The power cannot be exercised by mere asking. If the court grants an order without recording its findings on these preconditions, the order would suffer from error of jurisdiction. And in that instant case, the trial court did not go into the question as to whether the petitioner has made out a strong prima facie case to entertain him an order under Order 39 Rule CPC. Indeed, the court recorded that no order could be granted under Order 39 Rule 1, but proceeded to pass an order under Section 34C, read with Section 151 CPC. The court has come to the conclusion that the order under revision does not satisfy the requirements of a valid order under Section 151 CPC, inasmuch as the court has not gone into the question as to whether the petitioner has established a prima facie case and whether the balance of convenience lies in favor of the petitioner to entitle him to get an order of injunction, restraining the respondent from winning the suit property. According to the petitioner, in the light of the said order, even in this case also, the prima facie ingredients are not satisfied. As such, the court went wrong in granting an order. In the very same judgment, the court has observed that the inherent powers of the court under Section 151 CPC will not limit or otherwise affect the inherent powers of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of the court. And relying on the judgment of the apex court in Manohar Lal versus Seth Hiralal, reported in AR 1962, SC 527, the court observed that it is now well settled that where Order 39 does not apply, the court has inherent powers to grant injunction in appropriate cases in exercising the inherent powers under Section 151. In this case, admittedly, an injunction is granted, which is now confirmed by the appellate court. When there is an injunction restraining the defendant from interfering with the usage of the pathway in Schedule B property, and unless and until unless and until an order is passed under Section 94, read with 151 CPC, preventing the defendants from raising any constructions in the suit B schedule property, the purpose of granting injunction would not survive. And the court, to meet the ends of justice, has rightly considered and exercising the powers under 94, read with 151 CPC, has rightly granted, has allowed the application, and this court finds no reasons to interfere. Accordingly, the court is making the following order. The petition is dismissed. None of the observations made by this court cannot be construed as an expression of this court. And the court shall proceed with the matter Dependent.
Sale number 4,
Check.
Archana Murthy for petitioner.
Petitioner minutes. My lords, the respondent hearing, my lords.
Yes,
My lords, the respondent.
use the mic. Yes,
My lords, the respondent herein filed OS, my lords, that is 286/99 for declaration and injunction against the petitioners and others, my lords. It came to be decreed, my lords, in view of the compromise, my lords. In that, my lords,
when is
that
the
is-
compromise?
my lords, it was decreed, my lords. I'll come to that point, my lords. In that, my lords, in survey number 235, measuring 3.05 guntas was allotted to the share of the respondents, my lords, and 1 acre was allotted to the share of the petitioner herein, my lords. And later, my lords, again she filed a suit for injunction against one Dundamma, my lords. In that, my lords, at the initial
Who has filed the suit?
respondent herein, my lords.
The
She
plaintiff
filed
in the-
OS 253/2000.
The plaintiff in the earlier suit filed another suit.
Please, my lords. Against one Dundamma, my lords. So in that, my lords, she filed a suit for permanent injunction in respect of the land bearing survey number, that is 235, measuring 3.06 kuntas only, my lords. Later, she filed an application under Order 6 Rule 17, my lords, seeking amendment so far as extent is concerned, my lords, and that is 5 acres, 9 guntas, my lords. That is including the petitioner's land. She has sought the amendment, my lords. So we filed an execution petition and requested that she has clearly violated the, my lords, compromise. In the compromise petition, it was 1 acre was allotted to the share of the petitioner herein, my lords. But here, my lords, by including my property, she has filed a suit for injunction, my lords. So we filed an execution petition seeking attachment of movable as well as immobile property, my lords. That came to be rejected. Against that, we have filed this petition, my
Come to the
lords.
order.
My lords, trial court has made an observation that
Let's
since,
go to the order page number.
please, my lords. My lords, reason starts from page number 44.
Please read.
May I read, my lords? This portion is filed alleging violation of the decree passed in OS 236/99. Admittedly, the said suit was filed by the respondents herein against the petitioner and another for the relief of injunction. The said suit admittedly ended up in compromise between the parties, wherein the parties have agreed for mutual title 7 possessions or certain extents of land in the same suit survey number property, and also the respondent herein was to get grant from the government. Allowed see a seal is there, ma'am. Property in their possession for which, as applied for regularization, but as is silent about the relief of injunction as sought for by the respondent who are the plaintiffs in the said suit. Further, as the said suit was filed by the respondents by paying the requisite court fee on their claim for injunction, if at all such injunction could be inferred from the compromise decree, it relates only in favor of the respondents who are the plaintiffs therein. Thus, in any view, there cannot be any order or decree of injunction in favor of the petitioner who was the defendant therein. Apart from the above, when the petitioner herein was the defendant in the said suit against whom a relief of injunction was sought had entered into a compromise, it means he or she has admitted her interference with plaintiff and agreed title and possession of the plaintiff therein. As such, there was no decree against the plaintiff therein. That being the case, question of plaintiffs violating the decree does not arise. The petitioner also relied on the suit filed by the respondent in OS 253/12 and alleged that by filing the very suit, respondent has impliedly denied the possession and enjoyment of the property by the petitioner, which amounts violation of the decree. But on perusal of the plaint in the suit, Exhibit P5, it appears very clear that said suit is not filed against the present petitioner. Further, it is alleged that respondent also filed an application for amendment of plaint for including some more
Compromise decree.
annexure A, my lords. It's in Kannada, my lords. My lords, the that is in para 2, my lords. And I'll just translate it, my lords. That is survey number 235, defendant number 5, my lords. 1 acre was allotted, my lords.
Super injunction, what is the compromise?
My lords, actually, my lords, it was for declaration and
No,
injunction.
the court observes that it's only a bare injunction, so.
But here, my lords, in somewhere it is stated that it is for suit for declaration. Here, my lords, in the decree, suit filed on 17/11/99 for declaration that plaintiff and her husband are the owners and in possession. So it was for declaration and injunction, my lords. So the very,
File this translated copy, then counsel the petitioner shall file the translated copy of the compromise decree.
please, my lord.
Yes. Next, this is matter on 4th of March.
Cell number 5, Madhukar Deshpande for petitioner, Keshav Bhatt for respondent.
Appearing for respondent, my lord. Appearing for the petitioner, my lord. In last hearing, my colleague had argued for some time. I may be permitted to appear, my lord, and address the argument. The petitioner is the plaintiff, my lord. He had instituted a suit for determination of tenancy on the ground that non-payment of rent. Then an application came to be filed, my lord. That application favored. And
What is that,
again,
that application?
an application is filed for receipt of the security bond and relieve him from the forfeiture. That is the relief which has been sought for. Then I filed an objection to that application. That application came to be allowed. And by virtue of that particular order, my lord, he is completely absolved, relieved from the forfeiture. My submission is that, my lord, the application what is filed with respect of receiving of the security bond, with respect of the arrears of rent.
Please come to the order impugn so that I'll understand what.
Yes, my lord. If my lords permits, may I request my lords to look into the prayer sought in the application, then I will take my lords.
We'll go to the order first, then we'll.
Yes,
come
my
to that.
Yes, my lord.
Order.
Yes, my lord. The order, my lords, would start at page number 44, annexure E, my lord.
I'll start reading from the reasons.
The reason starts at page number 47, my lord.
Yes.
Para number 6, my lord. The peruse the application and the submission of the counsel. The suit is one for relief of possession. On perusal of the document, it discloses that the suit scheduled property was given for a lease for 99 years under the registered release deed dated 9/5/1966, which was executed between the plaintiff and
The case that till the entire, the duration of the rent, the entire amount is paid.
Yes, my lord.
Oh, this is about the matter.
yes, my lord.
What is your difficulty?
No, my submission is that, my lord, the hardship what is underwent by the mutt or the plaintiff between the period 2007 and 2012 when I issued the notice and subsequent to 2012 on the day when he offered or tendered to pay the rent, or whether by virtue of this particular order passed by the court below, whether the proceeding has to be terminated is the question, my lord. My submission is that the order what is passed will not terminate the suit proceedings. The court, after receipt of that particular amount or whatever the security bond is received, the court has to conduct an inquiry, has to consider the merits of the case, whether there is a hardship or not. And thereafter, the court has to pass a final order. This particular application will not prejudge or finally determine the rights of the party. And
What is the difficulty of the matter? You are receiving, it is a tenancy for 100 years.
99 years. 99.
So that 90 years, till that 90th year, he has paid the entire rent now.
No, he has paid the entire rent after not paying the rent from the year 2007 to.
What is the difficulty?
That is it is not the question of difficulty.
It is about like, Mutt has so many other things. Why did you want to?
This is
pursue
our property.
unnecessary-
This is our property. We want to utilize this.
If this person is not there, you will give it to the rent on lease. to
Yes, my
another
lord.
person.
Definitely, my lord. We will give it to.
The rent,
the-
why do you want to pursue this matter?
If a person who is squatting in the premises without paying the rent, whatever the rent we had agreed, and I am entitled to initiate the proceedings, my lord, and I am entitled to explain the hardship. And for that reason, I have, my submission is that the application can be allowed, but not that the entire proceeding has to be terminated. I request my lords to kindly consider the application, my lord. What is the relief which has been sought for? And then, my lords, I will place 2 or 3 judgment on record, my lord. which says that that application will not terminate the
What
proceeding.
is the order? What is the order passed
Yes,
by
my
the
lord.
court? Come to the penultimate paragraph.
Yes, my lord. The application filed by the defendant under section 151 CPC, read with section 114 of Transfer of Property Act, is hereby allowed. In toto, it has been allowed.
It's an application filed under 151 CPC.
Yes, my lord.
Hmm.
Then the entire proceeding has come to a stall.
What is that?
Yes, my lord. The application, if my lord takes page number 29, the typed copy of the application is at page number 35, my lord.
Yes.
The relief, what is sought in that application reads like this, my lord. That for the reasons stated in the accompanying affidavit, the petitioner defendant prays that this honorable court may be pleased to accept the security furnished herewith in lieu of making a decree for ejectment and pass an order relieving the defendant against the alleged forfeiture of the lease in the ends of justice and equity. He can seek for the deposit of the amount. I'm not saying that he cannot seek for that, but at the same time, he cannot seek a relief that he will be relieved from the forfeiture. Whether he is relieved from the forfeiture, whether there is a determination of tenancy, this is a question which has to be decided by the trial court.
Why do you think that the entire suit is terminated?
My lord, this is the relief which has been granted to him, my lord. If the
Might have asked for it. What did the court say?
the entirety, the application has been allowed. I request my lords to kindly take last page, my lord, that is page number 52. The application filed by the defendant number so-and-so is hereby allowed. And the court comes to a conclusion that it is the absolute right. The court has gone to the extent of saying that it is a statutory right of the tenant to offer it, receive it. Once it is received, there is an end of.
Yours.
Yes, my lord. My suit is, my lord, I request my lords to kindly take page number 11, my lord. Annexure A is that suit, my lord. Para number 5, my lord, I have explained that from 2007, he is in arrears of rent.
No.
Yes, ma'am.
Sought for ejectment of the
Yes,
tenant.
ma'am. Yes, ma'am.
It has to be decided by
Yes,
the
ma'am.
court.
It has to be decided.
Then why do you think that the entire suit is terminated?
My lord, he has been relieved from the forfeiture. That is the relief what he has sought for. In the application, he has not sought just for the deposit. He says that the section 114 is a substantive provision which requires to be.
The suit still has to be decided.
Yes, my lord. This is my.
Vacant possession of.
Yes, my lord.
What is your relief? A decree in favor of the plaintiff.
Yes, ma'am.
Directing her to surrender vacant portion of the plaintiff's scheduled property.
Yes, ma'am.
That is still to be decided by
Yes,
the court.
ma'am. This is what my.
Why do you say that the suit itself is terminated?
The relief, what has been sought for, which has been allowed is in that forum, my lord. Kindly take the relief, what is sought, my lord, which just now I read it.
It's an interlocutory application. The relief, the court, by that application, the suit, it cannot be said that the suit itself is terminated.
Yeah, this is how the court has.
Decide whether you are entitled, whether in spite of paying all this amount and all, whether he has to be evicted or not, the court has to decide it.
Correct, ma'am. That is what, but the order is not.
Can't understand it that way. That is an interlocutory application.
Yes, ma'am.
And still the main relief of A.
Yes, my lord. May I'm.
A sum of rupees so and so, this B has to be still the court has to consider.
Yes, my lord.
Mean profit, so many issues are there.
Yes, my lord. Not only that, the main prayer regarding the termination of tenancy also required to be considered by the court below.
Consider.
If that is clarified, my lord, I'm.
Consider.
Yes, ma'am.
How
Yes,
will
ma'am.
the suit go?
Yes, ma'am.
That I'll record.
If my lords permits, I will not read it, my lord. The manner in which the court has passed the order. If my lords look into para number 7, the para number 7, my lord.
Is filed.
In fact, my lord, with respect of the very same mutt, my lord, similar type of an order has been passed saying that suit has to continue.
Making a decree for ejectment, pass an order relieving the defendant against the lease forfeiture of the lease in the ends of justice and equity. It is the case of the petition hearing. It is dated 12th June 2019. The plaintiff herein has filed a suit seeking the relief that seeking a relief, seeking a direction against the defendant to surrender vacant portion of the plaintiff's scheduled property in favor of the plaintiff. A decree directing the defendants to pay a plaintiff a sum of rupees what is that?
4,266.
7. Directing the defendant to pay the plaintiff further main profits from 1 to 2014 to till delivery of vacant portion of the plain property at rupees 200 per month or at such rate to be determined by the court after holding necessary inquiry. And for also to pay the cost of lawyer's registered notice. In the suit, the present IA came to be filed by the defendant. And as IA number 1 is filed, has filed an application to accept the security furnished and in lieu of making a decree for ejectment, pass an order relieving the defendant against the lease forfeiture of the lease in the ends of justice and equity. The court had allowed the application and the court has observed that the document clearly establishes that since 1970, the father of the defendant was in possession of the property. After death of his father, the defendant continued to be in possession of the property till today. And further document reveals that till 2007, the defendant has made the payment of rent. From 2007 onwards, the defendant was due of payment of rent. Admittedly, the suit is filed on 7/2/2014. And summons to defendant was served on 19/3/2014. And the defendant appeared on 3/4/2014. And in the meanwhile, the defendant has made the payment on 26/2/2014 through DD number 114198, and the same was sent to the plaintiff Mutt. Further, the document discloses that on 10/3/2014, the plaintiff Mutt have been returned the DD by saying that they've already initiated suit against the defendants. The court observes that according to section 104 of the TP Act, if at all, the lessee has made a payment together with interest and his full cost of suit or give security before first hearing, the lessee shall hold the property leased as if the forfeiture had not occurred. Since the defendant has already paid the amount which was due by him along with security bond, his right has to be protected under section 114 of the DP Act, and he shall continue as a lessor and accordingly allowed the application. Aggrieved thereby, the Mutt is before this court. Learned counsel appearing for the Mutt submits that they have sought for ejectment and also other reliefs against the defendant. Just because the manner in which the order is passed, it appears that the entire suit proceedings were terminated. He submits that unless and until the court decides all the issues and the relief that is sought, and a detailed finding is given by the court, it cannot be held that the suit proceedings were terminated. Learned counsel appearing for the defendant submits that when they have paid the entire amount for the entire period of lease, the plaintiff cannot have any objection. And even in case the petitioner, the defendant is evicted, they have to again induct another person into possession of the property. In such case, the continuation of the proceedings against the defendant will not serve any purpose, except having heard the counsel on either side, but it's a material on record. The plaintiff Mutt has filed the suit for ejectment and for filed a suit for possession and also sought for other reliefs. The defendant has come forward to deposit the amount, and by order impugned, the same was allowed by the court. Still, the court has to decide the other reliefs that are sought, and the plaintiff is entitled for the, any other cost or interest because of the lapses on the part of the defendant. As far as those issues are concerned, the court has to still decide the same with the above observations.
Lord, my
The-
submission is that main issue itself, it has to be decided. Even that my hardship also required to be taken into
That's
consideration.
what if your hardship,
It
for
is,
your hardship, whatever or the costs that are required has to be, but
no,
not.
even the main relief survives, my lord. If even main relief, that is my contention.
The court will decide about any other relief that the plaintiff is entitled with the above observation.
Any relief in the sense, my lord, in the sort in the plaint, my lord. But otherwise, it will be interpreted in other way, my lord. Because I am relying upon two judgments, my lord. What it says that particular amount has to be received, then the further proceeding has to continue whether there is a determination of tenancy or not. That is what required to be decided, my lord. I may be permitted to rely upon those two judgments, my lord. For that reason, there is one recent judgment which has been in that particular judgment, the Supreme Court, even though it is an arbitrable, the arbitrator is required to pass an award. But otherwise, yes, yes.
In his contentions.
I'll just refer to few paragraphs, my lord.
Has relied on the judgment of the apex court in Suresh Shah versus the Hyper Technology India Private Limited reported in 2021. 1 SCC 529, which para?
Para 15, my lord. Para 15. Then 16, 17, my lord.
15, extract.
16 and 17, where the Supreme Court has held that the court has supposed to take into consideration section 114 as well as the deposit of the amount. Thereafter, the court is supposed to, the arbitrator is supposed to proceed with the matter regarding termination of the tenancy. So that is what I am submitting, my lord.
Yes.
So all the relief what I have sought in the plaint has to survive, my lord. Otherwise, only the consequential relief survives. Then it is nothing but predetermining all the rights for that reason. That may be observed, my lord.
I'll look into, yes.
Cell number 6, Arun Govindraj for petitioner. Kiran Seven.
Respondent is not. We passed over this. Respondent is present before the honorable court.
No,
There is a direction. There is a.
no, that is one. Why did she make such kind of a statement? On the last occasion, you were saying that you were not on record at that particular point of time.
Correct, ma'am.
No, the client is before the court.
Yes, ma'am.
She has to answer to that. What is this conduct of the client? She is not an illiterate. She is a well-qualified person. And why these kind of submissions are made before the court? It is only to see that everything is put in an end. I've asked them to withdraw all the proceedings.
That is not done, my lord. Yesterday, the matter was listed. That was not done. Today,
So no, that is one aspect that will be
Yes.
done. What is her answer to what all she has done?
see, during the pendency of the issues between
She
them,
has submitted before the court several times. She appeared before me in the chambers. She was talking about the school. She was talking about so many things. She never told informed the court that the girl is out of Bangalore. She never informed that. Is she not supposed to be like fair to the court? And won't it amount to perjury? Won't it? Advise her, this is not the way.
I've advised her, my lord. After I stepped in, I advised her, I told her to settle down and settle all the issues, not to aggravate anything. I've told her. And she's agreed with me. That's why this matter is settled. 27th of November, I filed my wakalat. 13th of December, we've closed the matters. I've advised her. And we are not
What
aggravated.
is she saying about why those kind of suppression of facts before the court? Can she afford to do it? If those proceedings are continued, what would be her fate? If the proceedings are continued and the court comes to the conclusion that such wrong affidavits are filed before the court and the perjury proceedings are initiated, what will happen to her? She can't take the courts in such a, in this manner. Yes, Mr. Gondra. Yes.
She has an apprehension, I will take my child and go away from India. Now my passport is with her, she's staying in Dubai. My passport is with her. As per the settlement. As per what is.
Anyway, she's an Indian citizen, right? She's an Indian citizen.
Yes, she's an Indian citizen.
She can't afford to do all that. At least we can understand, no, she might be, but Dubai, my in the sense?
The agreement was that the child would be with him, the child's passport would be the father, and his, because he's a UK national, his passport would be with her. That's in the agreement.
Then
That is
if that
decreed.
is what is,
Now he wants to
agreed
change the
upon.
terms. No,
But anyhow, it is, the child is with you.
no, that is the contention which he
Then
had,
what
he knew
about the
about it.
school? Who is appearing for the school?
No, school has been.
You that? That is not a party on the behest of the school, on the court it is. What is he saying?
He's saying that other than the DCA, we have not sent the child out of the school.
When did she make the application for the TC? 18th June 24. When did you give? You given it immediately.
It was given on 15/6.
15? 25th June you have given.
Now the father wants to put the child in the same school. So whether the school is agreeing to admit the child, that is the question, my lord. 27th of September to 27th of October, the child was with the father. And he knew where the child is studying. For 1 month, the child was with them, and that's on record. No. But this is, who can take the child back since the child was there for 5 years, Lord, and she's been without any school for the last 1 year.
No, for giving her the admission, what is the difficulty to the school now?
Actually, they're not supposed to for a readmission. So if they again apply, if there are any vacancy, that can be.
Then without even doing all that exercise, why your client is making such a submission? Is it so? He has not. Where is he?
He was in the family for withdrawal. 3 days ago, he has gone to Vaishnavi Public School. He's made the child to fall on the feet of the principal, apologize. He has subjected the child to some medical tests. He's not keeping quiet. We are keeping quiet. We don't want to aggravate the situation. It is on affidavit.
Things now will not.
We have no objections if
can't
the school,
suppress all those
if the,
things
if
now.
the school is willing to take her back, we have no objections. ma'am.
In this, no, you have no. Only
we-
you are here as far as that application is concerned, which is withdrawn. No, nothing from the mother's side. She
Yes.
cannot say anything now. Yes. Are there any vacancies? Are there any vacancies? Because what you have to see is, Mr. Gondraj, no, for some reason, no, you have asked for, whoever is the custodial parent has asked for the TC. They've given the TC. No, under which law this court will direct them to take the child? And one more thing, what I feel is your client is being too, because the court is open and things are happening. So he is asking for every relief. It amounts to the same. Once a high court says to consider, that is more or less like asking them to do something, which they are compelling them to do something. That is true. Parent patria jurisdiction doesn't say that the school where she was not studying from the last 1 year, the school shall give the admission to the, I can understand for a month or so for the reasons between the parents, if she is out of the school and for that reason they are not allowing them, then the court will tell them, okay, consider their case. But it is not such a case. Right from 24, what he said, 24 June, she is not in the school. No, she didn't go through the academic year. No, she has to go back to the class where she started in 2024. So unfortunate, all these things.
The child is studying in Vaishnavi Public School, my lord. She is studying.
Then,
She is studying in school.
when?
The
from when-
SATS number is intact.
No, she has an admission in Vaishnavi school.
Yes, my lord. She is studying in 3rd standard now. She is doing her exams and he is aware that she was doing it online. She was doing it online. The father was aware. 1 month the child was with the father.
No, if I remember, Mr. Gondraj, when that 1 month order is passed by this court. No, that time, the father said he's taking care of all her online schools and all. To which school she is going, is not aware.
They mentioned that exams are there online. Then thereafter he went to the school, he went to the principal said, from foreign admission, child not to give months after the report also before your lordship. However, the report said last year.
No, that online classes are of which school?
That Vaishnavi would go online classes for head, no exam for head. That's why I find the memo brought immediately after custody, to me. I found that it's not studying that school also.
So he says that they have a Vaishnavi school,
Vaishnavi school is a letter.
saying that.
Child never come to school. Never come to school. 1 month the child is with the father. 1 month. She's doing online classes.
Why online classes? What is the big difficulty for her to go to the school? Why is the child deprived of her all these the education and other requirements? Is everything okay with the mother?
Everything is fine, my lord.
Then why was she having the online classes? Why not the regular classes? What is the big reason? There should be some reason to go for the online classes.
Dubai, no? From February last year. The passport is produced, along with all the immigration status, the child is not even in India.
Where is that?
I produced the passport, but page number 47 onward. Along with immigration status, nobody is aware of this fact. The child's passport is page number 43, or 42 and 43. And 44 onward, the immigration status.
Where is that IA? That application, when it dated, when did you file that? 23/1.
Those are Rajeshwar. It's good.
Huh.
Number 42 and 43 are the child's passport. The passport photograph of the passport. And 44 are the immigration seats from February child in Dubai.
February?
From February 2024.
Till?
Until it was brought, they didn't have to December. India Monday before the settlement agreement was signed.
That is December 2024.
Mother was traveling every year before the lordship. When she maintained child studying in Vaishnavi Public School, she was coming from Dubai. The immigration stamps are here. This is why I got a feeling before the family court. The order being paid not only on me, but also on the High Court and the family court. My lordship, there is a memo that is filed by them. There is a memo filed by them on 7th of November. No, I don't want to mislead this court. 7th of November, his memo, please, my lord,
No, no.
please, I need to see this.
Come to 43.
I don't have the copy. He sent a soft copy to me. Give me, no, I don't have a hard copy. Give me a hard copy. Give me a hard copy.
You have a copy.
Give me a hard copy. He has filed memos. Along with that, there's an email which is dated 1st of November 2024, which he himself has sent to the wife. In that,
No, before
he
we
stated,
get to that, one simple one. You don't have to look at the papers. They ask your client between February 2024 till December 2024, where was the girl and where was she? Just ask her and tell the court.
I was traveling on the interviews, madam. On September 28th, I have sent, I have told Venkatesh when I gave Kavya, and Venkatesh knows everything. On 28th of September, I have given email also. When I was traveling, the child was traveling with me, but in July, when she was attending the Nimhang sessions, and she was also attending the Vaishnavi Public School, and she's been admitted to the Vaishnavi Public School. She has been attending the exams also. These are the exam which she has written in Vaishnavi Public School. And I have given her tuitions whenever she was with me. And these are all the worksheets which she has done for the third class, madam. I want to submit everything to you. And I told my previous counsel also everything. They told that they will inform the court. And I told Venkatesh also through the emails. Our first email from me saying that I am looking for a job, I got the job, was sent on September 28th, madam. September 27th, when I gave my child to Venkatesh, I told him personally. I was going for interviews and coming, and child was coming with me and coming. But I was staying in Bangalore also, and I was staying whenever I went to interview. I was there. Only on business visa I have taken her, and she was coming back.
20 days stay in Dubai, come to Bangalore for 1 day for training, go back the same night. Another child being made travel from Dubai to Hyderabad to Bangalore, attend the court over here, the very next day go back to Dubai. The immigration stamps are not like. Page 43 onwards, our immigration stamps. They were not for 1 day, not for 1 day, for weeks on end. And coming to India only for 1 or 2 days. It's other, I don't know why the other side is making this difference. Video on record. Page 45. 16 Feb she goes. From Trivandrum Airport. Page 45, immigration, right on top. 16 Feb 2024. 17 Feb she enters Dubai. Page 45.
Now, what are the terms of compromise now?
But terms of compromise are still with me. I will have a child's passport. My passport, but I will guarantee that I will not take the child out of the country, he will be respondent. At that time, I was not aware of.
No, that is one aspect. Then who will take care of, for all practical purposes, father is the legal custodian of the child.
That is conditional, my lord, conditional.
If mother comes to India, I will allow her to have custody for 1 week. The only request I made to the family court, the petition was, let her give me her passport considering her conduct in the past. When she wants to take the child out within India for 1 week, let us give her passport so I know that she's not traveling again and violating the court order. A person was found acting before the court and has committed the misconduct. So it's capable of doing the same thing over and over again. Therefore, my request before the family court was, when she comes to India, let her take the child for 1 week. I don't want to prevent the mother from having access to the child at all. Let her hand over her passport so I'm assured that she's not taking the child and going away.
The condition is, the custody is conditional. When she is out of the country, she can visit the child, my lord. When she is in the country, residing and working over here in the country, there'll be 50-50. It is joint guardianship.
But that day,
It is
she
not
will
so.
send her to school or?
She will, see, I've guided her. I've advised her also. She will follow whatever's there. And even if she's taking the child abroad, she'll get a mirror order from the concerned country court. She will get a mirror order. And those terms were inserted by them. We have consented that.
Very unfortunate. Very unfortunate. Let the parents have what kind of disputes, but this is not the way the child will be treated. Sending her a 3rd class student, having online classes, going here and there. And telling her that I don't like my father, I don't want to do that and all. Yes, no, Mr. Arun Gondash, we cannot tell the court will not pass any orders. No, they are already now, they say he's coming to the court and he's saying that they have not approached. Let him show one application or one email that he has sent. Huh? But the school, they're saying that no such communication from them? Yes, mister, what is your name? So what they say that they've already sent? Oh, from the administration department. Can, oh, that mean, I'm not asking you about, what you can do. I'm asking you whether they've sent a communication, they've asked you for, they made a request. And do you understand what kind of, disputes the parents are having? It's yours is a good school. This girl, the child needs to, the more she wants to study there, as she was there in your school from 19 to 24. So under these circumstances, whether she can be accommodated or not, please get instructions from your principal and you can submit to the court when you can get instructions. Next week may not be possible. Can it be day after tomorrow? Hmm. Then we'll pass an order saying that the father has already approached the school. No, I'll record that. That is his submission and your submission also I'll record. That he has approached the principal and according to you, you have no instructions on that. If your rules, if there is any available vacancy for the admission, then let the daughter be, let that child be accommodated. So that if it is, that's what, if it is permissible and if it is possible for you, then do it. What is that? Can you, Mr. Arun, go under, let him use the mic.
See, from one class to other class, our own children will come.
Yes.
For example, third to fourth, fourth to sixth, like that. Next year, if there are any vacancy, if there are any dropouts.
Only if, that's what I'm saying.
That's
It's only
what-
If,
That's all.
if any vacancies are available.
Yeah, definitely.
And if it is possible for for your school, then give her the admission. That's
That
what will
same
be the
thing,
order
even
passed.
madam also told, I think yesterday he was there. Madam also told the same thing. If there are any vacancy, it will be given.
Yes. The IA number, what is IA? Mr. Gondar?
Direction for sympathetic consideration of readmission.
IA.
IA 1 of 2025.
IA 1 of 2025 is filed stating that the girl was studying in first respondent. Have you made the school respondent? Which respondent is the school? Second respondent, Kumaran School. And when the parties have entered into a compromise and when the passport was given to the father, he realized that the daughter was not studying in the school from February 20, which is that? From June 2024, where the mother had taken the TC from the school. And after that, after the settlement, when he approached the school authorities were not permitting school authorities have stated that the TC is already taken by the mother and they cannot give admission to the girl. Then counsel appearing for the petitioner submits that as his court in view of the disputes between the parties where the girl is studying from 2019. And because of the lapses on the part of the mother, now she is out of the school. And there can be a direction to the respondent school to take the girl, to give her admission. But it would be in the interest of the minor. This court had directed them to complete the school and issued notice to the school. Mr. What is your name? Srinath Viji. Your, what is your designation?
I am from administration,
No. What is your designation?
designation, accountant and admin.
Accountant and admin of the second respondent school is present before the court and submits that as the mother requested for the TC on 18th June 2024, they've issued the TC on 25th June. 25th June 2024. It is submitted that now when the next academic year starts in 2025 June, the children the children who are in the from class 2 will be promoted to 3, and from class 3 to 4. If at all the vacancies are there, and the school will consider if at all vacancies are available, then the school will consider the case of the what is her name?
Kavya.
School consider the case of the child Kavya. Though this court generally will not pass such directions, directing a court to give admission to a particular student, as it is a prerogative of the court to give admission and take decision in the best interest of the school as well as the students. But in this case, in view of the differences between the mother and the father, a girl was made to travel from one place to the other, and she was not even attending the classes. And in the month of June 2021, a TC was taken from the school. Thereafter, the parents have entered into a compromise, and now the custody is given to the father whenever the mother is not in the country. Considering the fact that the girl is studying in the particular school from 2019, the school authorities shall consider the case of the student Kavya sympathetically, subject to the availability of vacancy and the other rules of the school.
My lordship, maybe also mention that she currently enrolled in Vaishnavi Public School.
Land counsel appearing for the respondent mother submits that the child she after taking the TC, she has admitted the girl in Vaishnavi Public School.
In 3rd standard, my lord.
In third
Third
standard.
standard. Which area is this?
Yes, next.
KR Puram, Bangalore.
According in the light of the above, the light of the orders passed in I number 1, and in view of the settlement entered into between the parties dated
13th of December 24.
December 2024, the writ petition stands disposed of.
Obliged, madam. Obliged.
7, Harish Bhandari. Cell number 7, Harish Bhandari for petitioner.
I appear for the petitioner
Raghavendra
herein.
Gowda case.
The suit is one for partition, and the petitioner herein, who's the plaintiff before the trial court, had filed an IA for recalling her and subsequently furnishing of additional documents.
So which year is the suit?
The suit is of the year
2014.
14, Your Lordship.
When was your evidence?
The application was filed in the
When
year
your
19.
evidence is completed?
This application was produced at the time of the arguments, Lordship.
Yes. So for that, I want to know when your evidence is concluded.
The application was produced in the year 2019. So prior to the application being filed, it was posted for argument. As DW3, one of the witness not being produced appear before the court, his stage was taken as nil, and subsequently it was posted for argument. So around 3 to 4 months back, I had earlier filed an application, similar application, for furnishing the same documents, but presently I have engaged in other counsel, and I could not be present before the court, and the stage was taken as nil, and subsequently the present application is filed.
Impugned order.
Yes, Lordship. The only reason for rejection of the document is, Lordship, that
No, please come to the order.
Yes,
Please
Lordship.
read it, then we can make your submission.
at page number 40 of my petition at annexure C,
Yes, please read.
page number 42, Lordship, the plaintiff filed IAs for recalling the PW1 by reopening the case for further examination of chief. On perusal of the affidavit filed by the plaintiffs, there is no any discloses about which documents have to be produced by the plaintiff and how they are relevant to the present suit. That's the only reason
No,
for
that-
rejection
that
of the
is not
document.
the only reason.
Yeah.
That is the reason.
No,
Because
Lordship, but-
come to your affidavit. Affidavit that's filed.
It is in
support of
Kannada,
the
Lordship, but wherein she has clearly mentioned which document she wants to produce. The document is, Lordship, the defendant number 1 before the court is one of the family member.
The petitioner shall place before this court the affidavit that is filed in support of the IA.
That's it. They are enjoying interim order from 6 years. Earlier, they prior to this impugned order, my lord, 6 months prior to this,
If you file, I'll hear it Friday.
my lords.
If you file that translated copy, I'll hear it on Friday.
Allah, my lords, they are aware, my lords, it was listed before my lordships for 6th time. They have not.
You say.
Allah, that only my lordship, only which is in Kannada, my lordship. That is my lordships mentioned in. There is a findings of that, my lord. Their contention is recorded in trial court order.
Understand, that is the only document that the court needs to look at.
Please.
It is just one para. You want it to be, if you want this court to hear
Please, my
at the
lords.
earliest, you file the translated copy, I'll hear it.
Allah, I may be permitted to say another one thing, my lordships. Prior to 6 months, my lordship, she is in habit of filing recall applications.
Understand. Court has to
Please,
understand
please,
the
my lords.
facts.
Any short date may be given.
Either it is Friday or it is not in February.
Please, Friday, my lords.
Yes, list this matter on Friday. By the time the translated copy of the affidavit shall be filed before this court.
Obliged.
Yes, next.
Seal number 8 for orders matter. Case Mahadevan for official liquidator.
Yes,
Hello, my lords, with your permission, may I submit, my lords?
yes.
My lords, this is the case, my lords. The original application was CA 239 of 2019, which was sent for evidence, my lords. It was filed under section 446.
Hmm.
Now, my lord, the evidence was ongoing. Then official liquidator wanted to adduce as evidence 2 more documents. And official liquidator had filed a memo regarding the same. Now, my lords, the Honorable Court allowed official liquidator to file not through a memo, but through an application, which is listed today, my lord, CA 362 of 2024.
Give that. Yes.
Now, my lords, what has happened? They have filed an objection to this application for me to adduce evidence. Now, my lord, to mark the evidence, there are 2 more additional documents. Now, my lords, if my lords may have CA 362 of 2024.
Yes.
Yes, my lord. My lords, on page 5 of the application, in para 3, there is a table, my lords.
Yes.
My lords, in that table, I am trying to mark these documents. One would be certified true copy of addendum to sharing agreement dated 6/7/2007. Now, my lord, this agreement is basically an agreement between PEPL, Prestige Estate Private Limited, and the then UBHL when it was not under winding up.
I don't want to disturb him, but the prayer seems to be, my lord, seeking permission to mark these documents. I have advised them now, my lord, that they should not object. Subject to proof, it may be allowed. Ultimately, all documents should come into the trial, but we will contest. So
Yes.
I don't think, my lord, we should.
My lords.
Please.
Heard what the senior counsel is saying?
Yes, my lords, there is another request. I am so obliged, my lord. The senior counsel is not objecting to it. My lord, the CA 388 of 2024, which is there, may be de-tagged with this, my lord. That's a separate matter, though belonging to the separate property, but the subject that has been filed by the respondents against the coercive action taken by the official liquidator. It may please be de-tagged, my lord, and any date would be given. I'll be highly obliged.
You appear in this.
Please, I appear in that. What has happened is the original company application is for determination of rents. This is a 55-45% ratio. 55% ratio, Prestige has agreed, not they have allowed us to continue. This is a salon, not very famous salon here and 10-year-old. 45% there is dispute between us as regards the determination of rent is concerned. The main prayer in the original application is for determination of rent. And they also demanded about 2 crores and odd. In the meanwhile, during pendency of that, where evidence is being recorded, they sent us an eviction notice saying that we will cut all the facilities if you do not pay about 4 crores and odd. But that is how much we had approached your lordship. Your lordships directed us to pay 2 crores, which we have deposited and complied with it. My request would be, my lords, since the main question would be as to determination of rent, during the pendency of that, until the final conclusion is reached, there cannot be a demand by the OL in so far as the present rents are concerned. Therefore, my lords, my request would be to keep this CA 388 of 2024 pending final adjudication of the original application.
May I make one submission, my lord? I'll add to what official liquidator has just submitted, my lord. Yes, I agree with the senior counsel in terms of submission that the original, the first application of 2019 is for determination of rents. The reason why a subsequent 2024 application was filed was because even the first CA is for arrears of rent still filing, my lord, and continuing to pay future rents, my lord. The future rents were also not paid, hence the coercive action was taken under a further notice.
No, what exactly is?
No, kindly see, my lord, the prayer itself. But
No,
may I
no, what exactly is the case of the tenant?
Lord, my case is that Lord, the 55% owner Prestige has agreed for a particular rent. There is a particular amount Lord, which we have calculated. We are paying them. Insofar as they are concerned.
As far as that, whatever that admitted rents which your client is.
Yes, we are ready to deposit. But
Are you depositing it or not?
No, they did not accept it. That was the difficulty for us.
So what
That
is the
from
difficulty
the
to-
beginning, I say, Lord,
No,
we are ready
what
to.
is the difficulty first to take the rents which are paid and they are subject to the determination by the court? Why
My
you-
lords, I am really sorry to submit. There has been nothing done by official liquidator to refuse the rents which are admitted. And my
No,
lords,
we'll do
the
one thing. We'll
I
do
do
one
not
thing.
want
regular
to
rents
join
are also
issues.
not
No.
forthcoming, my
Mr.
lords.
Owen, we'll
Yes,
do
my
one
lord.
thing.
Yes,
We'll
ma'am.
ask them, what is
Yes.
what is that admitted rents according to them? Let them deposit the entire rents,
Please, Lord.
admitted ones. Then in that case, till the other things were determined, you cannot take any coercive steps.
Please.
My lords, one addition, my lord.
Yes.
My lords, there is no agreement. My lords, my learned friend is there, the panel advocate.
During the
is
pendency,
there,
my lord, the lease came to
No,
expert. That's all.
whatever
Yes.
it is.
With respect to extension of lease, my lord, there is one question that only the part co-owner has extended the lease,
Mm.
not the
That
official
is
liquidator. The
another develop.
Prestige, my lord.
Prestige.
So there are in terms of calculating the admitted rents, my lord, the difficulty is that initially there was a higher off rate decided, which is higher off a fixed amount or percentage of sales, my lord.
Revenue.
This revenue details, my lord, are not being shared with us. So we are taking steps to get this information, my lord.
Oh, it
They
is
are
there. No,
willfully.
No, I understand.
Please.
No, this is all in dispute.
Please.
About what is that share and what is the rent, what is admitted, not admitted.
Grateful, my lord.
No, let whatever they are saying,
Okay, may
whatever they are saying,
I appreciate.
let that first be deposited.
I appreciate, my lord. Let them
I
deposit.
will
my
file
lord.
a memo before, one second. I will file a memo before your lordships as to what is the rent I am paying to Prestige, which is on record. It is not that we will be signed. Same one, let them accept it, subject to my lord's final determination by
Final
this honorable
determination.
court.
No, it is ultimately you have to realize the
And
amount.
we also, my lord,
Part of it you realize that
Please,
it is subject to the, the
CA.
further orders to be passed by the court. in
Appreciate it,
application.
my lord. We
Now, the first application is this CA number 362.
please, my lord.
yes,
This we will order subject to proof and relevancy.
Please, my lord.
Yes. Then the other one is that in that also.
that
we'll
is
pass-
388 of 2024.
In that we'll pass
The
this.
lordships
order
may
that
direct us to file a memo of the admitted rent. But we'll file based on that memo.
Along with payment.
No, we have paid two courses. Yes.
It's like this. Whatever your admitted rents, they will
Please,
not
please,
admit.
Lord.
So you have to come up with the admitted rates and the
Certainly.
payment also.
No, we will file with a memo. Lord. Once they accept it, we will make the payment.
It's nothing to accept. They'll not accept. That's the whole crux of the issue.
But so I will advise them accordingly.
Pass an
And it's a
order.
going concern, right? It is doing well. I mean, whatever, in between that COVID period, right, that they were the first to be hit. All these salons were the first to be hit. For 2 years, they were almost closed. It is because of that, not this derailment
So
happened.
that after that COVID,
Yes.
we are about another
No,
3 years.
it
have
is
added
right.
to
It's
that.
slowly picked up. No?
And
Anyway,
2,
I'll
3
advise
years,
them.
nothing has been paid.
Well, they
My
did
lord,
not accept it. That was the.
2, 3 years, nothing is paid.
And now we have paid 2
The
crores.
latest
2
2
crore
crores has
25
been-
lakhs has been paid.
It is a high-end salon, my lord. The 2 crore rent is barely anything.
Yeah, 2 crore
Let
25
them
lakhs.
pay the admitted rent. I'll make my submission. I have no objection in continuing the interim order.
How much
subject-
time you require?
2 only you paid.
I thought 32%.
But we'll file a memo, but there's some confusion because what he says is post 2022, they have been paying 32% revenue share even to the oil, but I want to cross verify and file it.
My lord, along with the details of their revenue, my lord, if they file that memo, we'll also have assessment as to whether it is correct, how far, by how far it is missing, and we can
Okay,
make
then
that
we'll do like
submission.
this, we'll ask them to file a memo with
Please.
all the details. And then, no, it is like, then you come up with whatever your objections are.
Please.
Then we'll ask them to pay the so-and-so amount
Grateful, ma'am.
by fixing a timeline.
Please.
Grateful, ma'am.
In fact, the entire dispute can get resolved. If they have to accept it, the rentals differences between us and them is very narrow.
As this aspect is concerned, the tenancy is not, it's an admitted tenancy. There are
Correct, correct.
some documents.
We
And
are
So there's no dispute about tenancy.
so many years, I think it is better in a phased manner, in a speedy manner. If the
In fact,
things
Lord, the
are
Honorable
resolved-
Justice Michael Kuna was appointed as a mediator in this matter.
Who?
The Honorable Court had appointed a retired Honorable Judge to appoint a mediator. Unfortunately, they couldn't come to a common. Then thereafter, Lord, the court directed the evidence to be recorded. But anyway, we'll make one more effort.
The CA number 362 of 24. This application is filed by the OL to direct the CPC to mark the certified copies of the documents filed by way of memo on 2/1/2024 as exhibits in affidavit in lieu of evidence filed by petitioner. It is stated that the official liquidator has filed affidavit by way of evidence on 3/11/2023. Thereafter filed memo on 2/1/2024 enclosing the two copies of the documents as evidence in CA number 239 of 2019. They are the certified true copy of the addendum to sharing agreement dated 3/7/2007, certified true copy of the addendum letter dated 16/8/2016. It is stated that unless those two applications are taken on record as exhibits, it would cause a lot of prejudice to the petitioner. Shall I record that the respondent, the Lenny Senior Counsel appearing on behalf of the respondent submits that the said document can be taken on record as exhibits, subject to the proof and relevancy. Considering the submission of the Lenny Senior Counsel, the CS 362 of 24 is allowed to mark the certified copies of the document filed by way of to mark the certified copies of the document dated 6/7/2007 and 16/8/2016, subject to proof and relevancy. Next, this is a separate order, CA 388 of 24. The learned official liquidator submits that this application can be independently heard as the application is filed by the tenant who is the applicant, restraining the official liquidator from interfering with the applicant's position and usage of the Schedule B property, including by way of restraining them from disconnecting the utility services to the property. Initially, this court had passed an order. Give that.
Yes, the order is, Justice, can you give? Order dated.
An order was passed by a coordinate bench of this court on 14/11/2024. That recorded that pursuant to the order passed by the court, the applicant has deposited a sum of rupees 2 crores and accordingly the interim order earlier granted is extended. Extended. It is submitted by the senior counsel appearing for the applicant is there is a dispute with regard to the admitted rents. In fact, the applicants are ready to pay the admitted rents. And with regard to what the disputed rents are concerned, that would be that can be adjudicated by the court in the main that is 3. That is the company POP number.
Yes, 239 of 2019.
239 of
2019.
and 239 of 2019. In view of the same, the applicant shall come up before this court. What are the admitted rents by way of a memo, and the same shall be served on the official liquidator, and the official liquidator shall file objections within 1 week thereon, if any. And basing on that, the further orders will be passed. This is matter when?
After next month, just.
Next month.
Yes.
This is matter on February 18th.
My lord, along with the memo, my lord, let them make some payment.
No, we'll pay, my lord. We'll pay. Let them.
Yes. An interim order earlier granted is extended.
Wait.
The next date of hearing. Yes, next.
Sale number 9.
Yes.
Number 9 is.
Yes, my lord.
My lord.
Yes.
Yes.
My lords, that would be the case of Louis Vuitton, my lords. In this last time, Honorable Court had ordered that we had to come up with the objections of the para 10 of their objections, which they have given. According to them, they have paid the whole rent. Now, my lord, we did the calculation. The problem is, my lords, they have taken a certain value in a year. We have taken as per lease agreement. Those values were not matching. Now, we sent a mail on 31st of January to Louis Vuitton, my lords. And we got a reply from Mr. Mudit Bansal saying that he is currently on leave and he'll resume work on 4th. So, my lords, since they have paid majority part, my lords, it may be kept for next week. Meanwhile, if they can reply, we'll calculate and file it before the Honorable Court, my lords.
My lord, the direction on the last date of hearing was for them to provide a calculation sheet in respect of the claim made in the
We
application.
have provided already. That was given.
I
in
may get a
court
copy
also.
of that. I can.
Yes, yes.
It is submitted by the official liquidator that already they've already given the memo of calculation.
I just got a copy. Over email, it was not shared, Your Honor.
Memo of calculation to the Learned Counsel for the applicant.
No.
And also they had a communication. They sent a email, Learned Counsel appearing for the applicant submits that they have not received, received, applicant is the official liquidator in this.
Yes, my
The
lord.
respondent submits that, the respondent submits that they have not received the memo of calculation. Now they have received it and they will, within a week. Yes, Mr. Counsel, within a week.
2 weeks maybe.
Within 2 weeks, they'll come up with the calculations. This is matter on 11th of March.
Please, my lord, I appear for the official liquidator on the matter, your lordship. Lord, again, this is a recovery applications, my lord. May I draw your lordship's kind attention to the order dated 13/12/2023, please, your lordship.
I appear for the respondent to this matter.
Lord, at the request of the.
Last date.
One minute, let me just look at it. 13, yes.
My lord, may I request your lordship to kindly order dated 13/12/2023, lordship.
Lordship, the respondent wanted to seek for further accommodation on the ground that statement of objection is unavailable due to personal reasons made in the order dated so and so. The matter is being adjourned, reiterating the observations made in the said order. Subject to the condition, the respondent shall pay a cost of ₹5,000 to the Karnataka before the next date of hearing. The objections to be filed and costs to be paid within 2 weeks.
Yes, my lords.
Then
That direction was there. I was a little delayed in making that payment of costs. Therefore, the KSLE did not take it. They said, you have crossed the time, I can't take it. I'm ready to pay the cost. My objections are ready. My lords may have this next week with one simple thing saying that directions may be complied within a week's time. I will place it on record my objections and the receipt for paying the cost. It is that when I attempted to pay the cost after the
we
timeline, they
submitted
didn't take
that
it.
as it was delay on the part of the petitioner to comply with the to pay, in paying the cost, the same were not accepted. The petitioner shall pay the costs by.
Responded.
The respondent shall pay the cost by 12th February and also. the
13th, my
object-
lords.
Even now you want time.
No, since I'm not there for 2 days, that's why I'm back on
13th,
Monday.
On 13th February, and by that day, the objection shall also be filed,
Yes.
or else the petition will be allowed.
My lord, here in this case, my lord,
Has-
admitted amount of 83 crores, my lord, it is
Or
due
if
from
that is not
2017,
fine,
lords. Please,
the petition will be allowed, or sufficient time is already given to
Grateful.
the respondent.
please.
Cell number 11.
Please, my lord, I appear for the official liquidator in the matter, your lordship.
Appear for the respondents.
Lord, the
Hmm.
pleadings are completed, your lordship. It requires to refer to the CPC, my lord.
It is submitted that for now, the evidence has to be recorded.
Please, your lordship.
It is submitted, the pleadings are completed, the party shall appear before the CPC.
Lord, I request to be have it some specific date, my lord.
Date on, we'll say on 18th?
Indeed, my lords. No
On 18th,
And-
so the
and-
dates they will give.
Grateful.
And may I also request your lordship may conclude the trial, my lord, within the stipulated time, your lordship, because the huge amount is due from the last 2017. my lord.
The the CPC shall conclude the trial in a fixed time frame.
Great.
Yes,
My lords, my apologies in seal number 10. If that order, my lords, could be uploaded by today or by tomorrow,
today itself it will be.
I will
uploaded.
go show that and I will make that
It
payment.
will be.
Because
every
that
by
is the
evening
only
they'll be
difficulty
uploaded.
today.
Yes, yes. they'll be
I'm
uploaded.
grateful.
Cell number
Yes.
12. Sitaram Rao, BC for petitioner.
Milords, I appear for the petitioner in the matter. Milords, paper publication has been taken, Milords,
Paper publication in
respect of
respect of
R1A.
R1A. Sarojamma.
It is already,
In this matter, I take notice to R1A and R1C. In the course of the day, I will file the work.
1 minute. The notice, the petition as per the order passed by this court had taken substituted service of notice on the proposed R1A by way of paper publication. Same is accepted. A notice to R1A is held sufficient. Land counsel so-and-so submits that is during the course of the day, he has instructed, he'll file the wakalat in respect of R1A and R1C.
R1C.
Then what happened to this R1D?
It is await service, Milords.
When was it sent? When was it sent? As far as R1D is concerned,
17.
I don't have the papers.
it
now.
appears that it is awaiting service as per the office endorsement. Then what about this hand summons?
Milords, it has been refused by the trial court advocate to receive, Milords. I'll file a memo to the
Thereafter
petitioner.
It is in respect of whom?
R1A to R1D. All of them.
R1A to R1D. No, A and C are already represented by advocate now.
Today, Milords, today they have come on record.
So you have, then what are left now?
So what-
R1,
B and R1.
R1D you have already sent. Now I think it is R1B.
Please, Milords.
R1D is
R1D
concerned
is
subject to
sufficient.
correction. He passed away on 17/3/2021. R1D.
That's what, bringing the LRs of this.
In-
D. This is R1D. Awaiting service of in respect of proposed LR.
No, it's already sent. No, I think B has to be served.
Milords, B is served, Milords, the cause list may kindly be seen.
Sir? Then it is complete, service is complete. Yes, 13.
The petitioner will be directed to serve the writ
Then counsel for the
compilation, writ
petitioner
papers on.
should serve the papers on the council appearing for R1A and R1C. Yes, next.
Milords, interim order to be continued.
Yes.
Interim order.
Yes.
In this case, I am appear for petitioner, my lord. I filed an application seeking steps to unsolved response through by subservice. There are certain objections, my lord. I will attend to it.
First of all, you will not file an application. You will not take steps from 16. Now you will take, again, they will raise objections. Why you are not complying with the objections?
No, I filed it a day before yesterday, my lord. Application filed day before.
2016 matter, till now service of notice is also not completed.
No, it's regarding some of the,
Shall
propo-
comply with the office objections by 11th February, or else the petition shall stand dismissed without further reference to the court.
please. Interim order may kindly be extended, my lord.
Interim order is extended till then,
Much obliged,
till the next date of hearing.
much obliged.
Yes.
14, VB Shivakumar.
I appeal for petitioners, my lords. Kindly a short accommodation may be granted, my lords. Will
Weeks time, default order.
oblige, my lords.
Next 15.
Sale number 15 and 16 disposed. Sale number 17. Rajiv BC.
Like kindly fix a date, my lord. I file a memo to withdraw this petition, my lord. Taking party signature, my lord, I will file a memo.
Friday?
I will file, man.
Friday?
Friday,
Ah.
7.
Illa beda, next week, 12th, my lord. I have to get a signature of my party.
This matter on 12th, and council submits that the party wants to withdraw the writ petition. Yeah.
12th, my lord.
12.
Please, ma'am.
Sale number 18 adjourned. Sale number 19.
What about 17?
19, I appear for the petitioner, my lord. I have filed two memos on 4th of yesterday. They may be posted before the court because some of the matters have been settled before the Lok Adalat. And
That's
some
what
of the,
you said that you will give the other numbers.
yes, my lord, I have filed a memo yesterday, my lord. It has not been.
That
You
is
that?
not put up.
Not put up. Tomorrow,
Not
when
put up.
council submits that, he has filed a memo giving the list of
Two memos I have filed, one which has been disposed of and
other
one
matters.
has to be referred to
This
Lok
matter
Adalat.
tomorrow along with the memo filed by the petitioner. Yes, next.
My lord.
And also tag the other matters as per the memo.
Yes. Sale number 20. Tomorrow.
Appearing for the petitioner, my lord, we have filed a memo as per the order of this honorable court dated 25/1 to serve the copy to defendant number 3 before the trial court. So we filed on 13th January, the memo. And one more, office has raised objection pertaining to filing IA number 16 and 17. And we have also filed that memo dated 25th of January.
Non-furnishing of PPF cover letter, etc. We corrected this to issue notice to RP for second time. Served copies to council for the respondent number 3 before the trial court. Where is that? Where is the signature of the advocate?
13th January, 30th of January.
ನೀವು ಮಾಡಿರೋದಕ್ಕೆ signature ಎಲ್ಲಿದೆ? Sir?
Hmm?
Acknowledgement sir, ನಿಮ್ಮ ಸರುದು ಅದಕ್ಕೆ signature ಎಲ್ಲಿದೆ? ನಿಮ್ ಸರು ಮಾಡಿರೋ advocate.
R2 ಸರ್ವ್ ಮಾಡಿ R3 RPD ಇಂದ ಕಳಿಸಿದ್ವಿ.
R3 ಗಲ್ಲ.
For R3 we have sent to RPD, man. We have produced the acknowledgement, RPD acknowledgement.
Memo of acknowledgement for having served direct petition copies to counsel for the respondent number 3 before the trial court. By the order dated 24/1/2025. Where is that?
We have sent to.
You should do what the court asks you to do. You shouldn't do whatever you feel like doing and
But-
file a memo. What is the order?
We are not able to locate the.
So you will do
Okay.
something what you want to do. What is the order? Hand summons on the learned counsel appearing for the respondent number 3 before the trial court and shall file a memo to that effect by 4/2/2024-25. The memo is filed, post this matter on 5/2/2025.
Please.
And what is the order? What did you do?
My lord, we are not
Will you
able to, we are not able to track the.
Then you should tell the
Take
court
number of
that
the-
you cannot do whatever you want to do.
Apologies.
The order dated 24/1/2025 shall be complied with within a week. Next,
Number 21. Awaiting service of this.
await service of notice.
22.
Post after service, 22?
Twenty-two.
In 21,
Yes.
the Lordship had permitted me to take handsomest to the advocate.
Hmm.
Advocate has died, it seems, he is no more.
Oh.
The advocate on record.
They have not engaged any other advocate.
No, nobody is appearing.
Oh.
Anyway, I have taken the process for the parties.
The petitioner, it is submitted that the advocate for the appearing for the respondent is no more. The petitioner shall pay process for
Has been
service of
done,
notice. Huh?
Process has been paid.
He says that already steps are taken. List after service of notice, 22.
22.
This is 22, not 21. No, he's mentioning in 21.
21 awaiting.
Yes.
Serial number 22, DM Manjunath.
The office objections raised on I number 1 of 22 and 1, 2 of 2022 shall be complied with within a week. Steps shall be taken in respect of deceased R14 within a week. And also process shall be paid in respect of R4, E, C, D, F and R23 and 225 within a week. If these steps are not taken within a week, the petition shall stand dismissed without further reference to the court. This will continue after lunch. Yes. Yes.
If that is the bathroom and he is not in a position to come, it may be taken up next week.
Serial number
33.
Have you informed the other side? No other side? G. Chandrakala for R1 to R4. The difficulty would be the advocate would be waiting for the matter. If you don't inform them, how will they know?
Tell them, tell us. Next week. it will-
He submitted that the counsel for the petition is unwell. This is matter on 10th of March.
Interim order may be
If
continued.
interim order is there, extended. As you regularly appear, you know that the procedure in the court is not to make mentions in the afternoon. That's my sincere request to all the advocates. And sometimes, the senior members of the bar make a representation and make a request. The court cannot say no. I can understand, you could have done it in the morning.
I want some instructions from Martha. I'll do it in next week. I'll send a registered post to them today. Next week I'll do it. I don't want.
Which matter?
Serial number 38.
And what are you saying? What happened in 38?
Yes, but. Yes,
I'll
38.
inform that.
The request of learned counsel for the respondent or petitioner. Petitioner lists this matter on 3rd March.
ಅಲ್ಲಪ್ಪ 22 ನಾನು ಕಾಲ್ ಔಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 21 ಅಂತ ಪತ್ರ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಅಷ್ಟು ಹೇಳಿದ್ವಲ್ಲ ಅದೆಲ್ಲ 21 ಅಲ್ಲೇ. 22 ಅಲ್ಲಿ ಯಾರು
22 ನಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಹೇಳಿದ್ರು ನೋಡಿ.
Madam, 28 ಇದೆಯಾ?
ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಸ್ಟೆಪ್ಸ್ ಆಲ್ರೆಡಿ ಟೇಕನ್ ಇರೋದು 31. ಅಲ್ಲಿ ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ಇದೆ.
Madam, 28.
ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ. ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್. ಸರ್ವಿಸ್ ಇಸ್ ಅವೈಟೆಡ್. ಅವೈಟ್ ಸರ್ವಿಸ್ ಅಂತ ಫಸ್ಟ್ ಮ್ಯಾಡಮ್ ಹೇಳಿದ್ರು. ಎಲ್ಲ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ರಾಂಗ್ ಆರ್ಡರ್ಸ್ ತಗೊಂಡು ಅದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆ ತರ ಮಾಡ್ಕೊಳ್ಳೋದು.
ಹೌದು. ಇದು ಕೊಟ್ಟಿದ್ದು ಸೀನಿಯರ್ ನೀವೇ ಕೊಟ್ಟಿದ್ದು ಇದು ಏನಕ್ಕೆ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಹೇಳಿಬಿಡಿ.
ಇರ್ಲಿ ಬಿಡಿ. ಅದು ಅಲ್ಲಿಗೆ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರಂತೆ ಪ್ರೋಟೋಕಾಲ್ ಅಲ್ಲಿ. ದೇ ವಿಲ್ ಸೆಂಡ್. Next sudden ಆಗಿ ಏನಿಲ್ಲ ನೋಡೋಣ ಸ್ವಲ್ಪ ಸಾಂಗ್ ಅದು ಅದನ್ನ
Serial number 32 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
32 ಇಲ್ಲ ಸರ್ ನಾಗರಾಜ ಟಿ
ಹೌದು.
ಇಲ್ಲ ಅಲ್ಲಿ ಮಾತಾಡ್ತಾ ನಿಂತಲ್ಲ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅಂತ ಟೈಪ್ ಇದೆ
ತಗೋಬೋದಾ?
ನಿಮ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ತುಂಬಾ ಇದ್ರೆ ಸೈನ್ ಮಾಡಿಸ್ಕೊಡ್ತಾರೆ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ
My lord, small submission, my lord. I'll apologize, my lord. Serial number 20, interim order has to be extended, my lord. Great.
Yes.
That's one submission, my lord. In serial number 41, my lord. My humble apology.
Why submission now at 2:30? No. Yes, call the list. Passwords. He's saying something about extension of interim order. Where is that? It's already signed. The man. Yes.
Serial number 23. Hearing on intercluster application, serial number 23.
Yes. So what's happening?
My client, what is aware of it? My client says that they will be in a position to offer 15,000 rupees and they are not in a position to pay anything more. Even if he is ready to pay 15,000, they are ready to even take that also.
He is ready to sell his portion, ready to buy your portion at 15,000.
Well, we are ready to, I have filed in my application, I have already said up to 14,500, I am ready to pay. That is what in my application itself I have said. Now, because he is making a counterclaim for the first time, 14,500, I said another 500 rupees, 15,000, not more than that.
Earlier, they were given consent
No,
only
no, no, no.
14,000.
No, there is no earlier what happened. Court is not concerned. Now their offer is that
14,500 rupees.
15,000.
If 15,000 rupees.
So, no, yours is 15,500.
Our offer is
which not,
15,500 rupees.
Which is not acceptable to him. Then if it is not working out this way, I'll pass orders on them and it's okay.
Please.
What is the total extent of land?
55 by 40 blood, it is about 2,000 square.
So what would be the difference between the figure which you are quoting and what they are
500
quoting?
rupees.
500, like what would be the total amount difference?
Among total amount, will be more than
10 to 11,000.
6-7 lakhs rupees.
In this 500?
Yes, my lord.
About 11 lakhs. There are two persons are there. Ours one.
Unnecessarily you're prolonging the litigation. No, he said 14,500. You said 15,500. No, he's ready for 15,000. If you agree for it and you amicably settle it,
I'm within the
please settle.
limited time, I will deposit the amount into the court also. Let them execute the release deed, take the amount immediately without waiting for a minute for that.
Our offer is 15,500 rupees. On that day, your offer
For-
15,000.
For me, they say that buying price is 15,500.
While
When I am 14,500, when I say, now they say 15,000 is also not possible.
even though they
This is unfair.
even though they are made a
Let us see.
14,500
Let's
rupees.
pass orders on the merits.
Till, please, madam.
Huh?
Please, madam.
Yes.
Lord, the order in the challenge
Yes.
is an order on IA number 8 passed in the FDP number 184 of 2010, filed under Order 26 Rule 10 B and C of CPC for appointment of an advocate commissioner for sale of the scheduled property by way of public.
For partition.
It is a suit for partition. It is in the final decree proceedings. The stage at which the
What is the suit scheduled property?
suit scheduled property is the residential house in which we two brothers are staying. The sister is, earlier there were 4 people who were entitled for a share. The other person who died, he has no issues. Now only the sister and 2 brothers.
The son, one sister.
Yes, 2 brothers and 1 sister.
And it is, it's only 1 floor building?
This only 1 floor building. 2 portions are there. One portion, the first petitioner stays. In the other portion, other petitioner stays. Before the trial court, a commissioner was appointed to find out the feasibility or otherwise of the partition. The report has come saying that it is not possible to divide it into 3 portions and give it to conveniently use by the sharer. It is at that stage this application 26 Rule 10 B and C has been filed. The first contention, limb of my first contention is that 26 Rule 10 A or B or C is not at all applicable to the proceedings.
Come to the order.
Please, madam. The order is at page number, Annexure K, page 85, madam.
Page 85.
85, madam.
Wrong bundle is given, there are no 85. Which is the case number?
FDP 184.
Number 20.
8255 is the writ petition. You are given.
8255 of 2018. Yes. Oh, mistake. There is a mistake by name.
Yes,
Madam.
page number 85.
85, madam. Order on IA number 8. This IA is filed on behalf of the petitioner that under order 26 Rule 10 B and C of CPC with a prayer to appoint an advocate as court commissioner for the sale of the petition scheduled property in public auction. In the affidavit, third petitioner has stated that as per the judgment and decree, they are entitled for 1/3 share in the petition scheduled properties. Accordingly, commissioner was appointed to make division of the petition scheduled property. Commissioner has submitted a report stating that it is not feasible make division of the petition scheduled property. As such, the petition scheduled property has to be sold by public auction and the sale proceeds can be shared among the parties in terms of the judgment and decree. Therefore, it is just and to appoint a advocate as court commissioner for sale of the petition scheduled property in a public auction. Hence, IA respondents have opposed the IA by filing objections contending that the Honorable High Court of Karnataka, while disposing of the RF 1838 of 2010, has held that the parties have to work out their remedy in the final decree proceedings in regard to the feasibility of division of the petition scheduled property. And if the court is of the opinion that it cannot be divided equally, then it is open to the respondents herein to pay market value of the share of the petitioners and retain the scheduled property. Said direction cannot be altered in the FDP. Scope of this proceedings does not include sale of the scheduled property. It is further contended that the respondents are holding major share. Hence, the question of sale of the property in public auction does not arise. If IA is allowed, respondents will put hardship, hence IA is liable to be dismissed. Heard so and so, so and so. Reasons. the petitioners reasons. Petitioners have filed this petition to pass final decree in respect of their 1/3 share in terms of the judgment and decree invoice number 6085 of 2003 in view of the dismissal of RFA 1838 of 2010 preferred by the respondents here in challenging the judgment and decree passed invoice number 6085 of 2003. The respondents have not disputed dismissal of RFA 1838 of 2010 preferred by them, challenging the judgment and decree invoice number so and so. So the judgment and decree passed invoice number 6085 2003 reached finality. So the petitioners are entitled for their 1/3 share.
What is the market value of the property as of now?
Market value, we would say, having regard to the location of the property, my
Fancy.
lord, it may not fetch more than 14,000 or
rate is
15,000
different
dollars.
than market.
You can say, what is the market value? It must be available that you can tell the court.
That is the reason the location of the property, my
I
lord,
wanted to know, what is the
Yes.
market value of the property?
it cannot be more than 15,000 rupees, my lord. That is what,
exactly?
8,000 is the guideline value, which the court has said that guideline value cannot be looked into. We are now offering 15,000 rupees.
No, the order of this court is,
Yes, my lord.
if the trial court opines that it cannot be divided equally.
Yes,
Then value of the share of the petitioners, and retain the property, value, to pay the market value of the share of the petitioners.
yes, my lord.
And retain the property.
Yes, my lord. That is the reason we are interested in retaining the property. It is our father property. We would like to continue there, and we have offered this price. The extent of the property, you will also would get it, then it is stated in para 3 of 6 itself. 54 into 44, situated at Rajanagar, Bangalore. Commissioner who was appointed to divide the petitionable property submitted a report stating that it is not possible to divide the petitionable property in question into 3 equal portions so as to distribute the built-up area equally into 3 shares. Basing on the said report, the petitioners have filed the present EA for sale of the petitionable property in a public auction by appointing commissioner and to share the sale.
What is
process.
this? On the other hand, it is pertinent to note that petitioners is referring to them.
Yeah, yes, my lord.
Petitioners have given offer to purchase the respondents 2/3 share by paying rupees 2 crores.
2 crores.
Now, the amount which you are offering to them comes to
It is
what
more
amount?
than that, my lord. The one share would be 1 crore. Now, what is I am offering, my lord, comes to more than 1.15 crores, my lord.
1.15
crores, my lord. 1.1815 or 1.15.
And alternatively, they are ready to receive rupees 1 crore towards their share.
Yes.
That's what is submitted before the
That's
court.
what they have submitted. Even before this honorable court, they have openly said that at the rate of 14,000, we are ready to take in 2018. We said, all right, you pay us, we will go. They have failed to file the affidavit before this honorable court. On the last occasion also, that is in April 2024 also, they have we have said that we are ready to take it, please give us. Then they have said that we are ready.
When is this order passed?
24, I think it is on 24/4, my lord.
2024.
Yes, my lord. In our
On 3rd February 2018.
first offer, first time, 2018 itself. Again in 2024, we said, all right, you give me that.
25/4/2000.
25/4/2024, my lord. Second time,
25/4.
2024.
Is there such an order
there is an order, my lord.
before this?
Is that- Yes, Justice R. Nataraj has passed the order, my lord. Just before vacation, summer vacation. I think it may be in a separate order.
20, you said date?
25/4/2024.
Petitioner number 1 and one of the sons of petitioner number 2 present before the court. And the learned counsel of the petitioner submit that the petitioners are willing to convey their share in the suit property to respondent number 2 at a sum of rupees 14,000 per square feet. Respondent number 2, who was present before the court, and the learned counsel of the respondent number 2 agree to purchase the share of the petitioner at a sum of rupees 14,000 per square feet as offered earlier, so and so. Why have you gone back on this representation?
In the meantime, after vacation, from June to December, we are made a meeting 6 to 7 times. Both we and Srinivas and other his brothers Krishna Kumar and also Sriranga Iyengar also to increase the price. Both
Then
we
what
have
made-
tried.
What made you to make such a submission before this court?
Since the matter is going on, we do not know on without our the intimation, they are move the matter now. Still, we are discussion about the increasing the rate. If it
No,
is an
every time
more
you're
than
going-
40,000
you're
rupees,
resigning
let it
from
be.
No, from every time, whenever the matters are coming up before the court, whatever is your submission, you're going back. You said 1 crore earlier. Before this court, you said 14,000. Now again, no, you say 15,500, but not 15,000. No, I'll pass an order that it's a house where it cannot be, they're all
Not
living.
feasible for
It cannot be sold.
Please.
Let on that 15,000, let them.
Please,
yeah,
madam.
we'll fix it at that time.
Please, we are ready to purchase the 14,000 rupees by that time. They are insisting us to increase the rate. We search the bit.
15,000.
Huh?
You give or you take 15,000.
Yes.
Either way.
Either way. And we offered to 15,500 rupees. 15,500
You will
rupees.
purchase for 15,000. You will.
The
you will
purchaser
sell
is
for
there.
some-
Purchaser is there.
There should be some reasonableness
Please.
on the part of your clients. They say they will purchase at 14,000, but you will sell your value at 15,500. But you will sell their share at 14,000. What is that? What is that scale?
We filed the affidavit in the year 2018. Higher rate. Even though they are, the other side is petitioner is accepting for 14,000 rupees. But however, after vacation, they are insisting us, let us go togetherly and sold the property for higher rate. We are also agreed for that.
Yes.
7, 8,
Shall I pass orders on the merits of it? I'll fix that 15,000 and.
Please, madam. Please, we are ready to purchase 15,500 rupees, something like that. Huh?
Purchase it. That's what he's saying.
If he is ready to purchase for 15,500, we are ready to give.
15,000, his share
Yes.
also.
Time schedule may be fixed within that,
Then why don't we'll have this on Friday. I'll record all this.
Please,
Come
madam.
up with a joint memo.
Please, madam.
Saying
I have no objection for that.
both of, or if not joint memo.
Please,
Come
madam.
up with your independent affidavits. I'll pass an order.
Please, madam.
Before this court, both the advocates as well as the parties are present. Learned counsel appearing for the petitioner submits that they are ready to purchase the share of the respondents at 15,000 per square feet.
Yes.
Or they are ready to sell their share at 15,000 to the respondents. Learned counsel appearing for the respondents by obtaining with the instructions from the parties who are present before the court submits that they are ready to purchase the share of the petitioners at 15,000. In this regard, they'll come up with their affidavits with regard to with their respective affidavits. List this matter on Friday. The affidavit shall contain the mode of payment and when the relinquishment deed they are going to execute and when the amounts are going to be paid. Yes, next.
Cell number 24. Rahul S. Reddy for petitioner. Giving us.
Correspondence, my lord.
I appear for the petitioner since.
Yes.
My lord, it may kindly be taken up after a week, my lord. Senior is out of station. He'll be back on Monday.
Why every time the matter gets adjourned? How many times it has come up before me? It came up on 17-1, 23-1, 24-1, 31. Court has no other work, but always list this matter, adjourn the matter. We'll
Apologies,
adjourn
my-
it on cause.
Apologies, my lords, but on the previous.
Intermodal
dates
is
we
there
have
in your favor?
No, minutes. What has happened? This was dismissed for non-prosecution. My lords had told me to address
This
the
is
argument on main
On,
matter.
On 17th of March, at the request of Lankaus for the respondent. Yes, next.
Cell number 25. Rachita Rashekar, petitioner. Arun Govindraj.
Yesterday's matter.
Your permission.
Huh?
With your permission. Instead of 7th.
Let it be on Friday, please get it on Friday. Yes. Yes.
Yeah, please. From, she is
Maybe she's online.
online.
Look at it.
Amshudeep.
Unmute your audio.
Madam, unmute.
Yes. Yes, what is happening?
Sorry, madam, I could not join yesterday.
Yes.
Madam, I have complied with the interim order that you passed, and I was complying, and my son was complying with the final order that you passed. But in October for Dasara vacation, when I took my son to my husband's place, he has beaten me and he has punched my eye, and he has also beaten my son.
Yes. When was it?
It was on 11th October. And I could not register the FIR that time because my eye was badly hurt. My right eye was badly hurt, and my son got fever by the night and had to rush back to home. And I registered the FIR after 10 days. And I did not know that FIR has to be registered immediately. After that, we cannot comply with this order, madam. Please. My son has got very, very scared. And every time my husband keeps telling him, if you don't come, I will take the police and come home. After that, also, he has come to my building, visited my building, and he has come to all the neighbors' houses and that we are thieves. Now, no kid in the building wants to play also with my son.
Yes, Mr. Arun Govindraj.
The allegation of assault. Kindly see along with my application itself that I have produced. The FIR not have been stayed by this court, and the observation made by this court is that FIR is registered only to get over your lordship's order. And subsequent case not in another criminal petition filed by the wife. This honorable court undertaking is given by the other side that they will comply with your lordship's order. I produced it along with the memo yesterday. No, this question of if the assault actually had happened, my lord, kindly see along with the application document number 3, page number 24. The entire day she's talking to me over the phone. The entire day she said assault happens at 11 o'clock. I have produced the call logs. The entire day she's talking to me on the phone about the son. The son was in my house. We were discussing, and he's even asked the father asked the mother, how is it that you're allowing? He wants to watch Harry Potter movies. You're even allowed to watch it. It's appropriate for his age. They're discussing on video call, not even regular phone calls. Document number 3, page number 24 and 25.
When did you file those documents? What are the dates?
Along with the application. On 7th of January, my application for modification, 7th of January. But it's unfortunate the respondent or petitioner as well has now gone on a path of completely cutting off the child from the family. Document number 3, page number 24. It is the day on which she says she was assaulted, 11th of October. At 1:56 p.m. she has called. Incoming call. Thereafter, I've spoken to her 1:58, 2 o'clock, 2:09, 2:12, 2:58, 4:47.
Did you inform the advocate what has happened?
Yes, I sent an email to Mr. Govind's office
When
also.
is that? When is that?
That was when he sent me an email. I don't remember the date, madam. But madam, I can tell you one thing, madam. As soon as I came back to Gwalior, the next day I have written an email to the police station of Sadashiv Nagar. And I have a copy of that email
No, but you said
immediately.
that- No, if it has happened on 11th,
Yeah.
as soon as you return means when did you return to?
12th morning. 12th morning was the earliest flight, early morning. There is only one flight. And 12th morning only I've come back and written an email to Sadashiv Nagar police station informing them of the whole problem, whole issue and requesting them to register an
It is
FIR.
on 12th itself.
Yes, madam.
Page 36.
Where is that affair?
The FIR. They're putting along with their application. you know.
Statement
Along
of
with
objections.
Page number 20.
Statement of objections, FIR
Page
is
20.
on, FIR registered on 21/10/2024 by Sadashivanagara Police Station. Kindly see.
Actually, this, when I was in Dharwad, my office received a call. There in Dharwad, saying that the client wants to speak to me because basing on the order passed by me, she came to Bangalore and she has been whatever assaulted by the father and all, and she wanted to talk. And my office has received a call. Then I told them that's not the way the client approaches. If she has anything, file an appropriate application through the advocate and then come to the court.
In fact, I may have to add one aspect, please, 1 minute. This is not an, it's not a,
She has not.
no, this is not correct. No,
Until.
that's,
But the insurance-
I'm sorry to,
Because violating the order. Then she responds and says, I've been assaulted.
no, 1 minute.
After the FIR, then says, I went stick to.
This is not a, we not a conflict between the two parties. We have to assist the honorable court. We also wish to place on fact the
So
same
let's
day
see.
when, and kindly see
When is the?
page
Let's
25.
go to the
page
crime
25.
number.
Yeah.
So
Kindly see
where do they mention about receiving of the?
page 25, it's there. On the same
25.
day, in fact, when she was at
1 minute, let me look at it.
page 25, the concerned hospital
date?
record, they say she was received by the hospital and the hospital authorities
11/10/2020.
on then only, and she immediately contacted actually the instructing counsel, and he also called me. I said to go to the police, and immediately with all the photos, videos she sent, immediately she contacted
So where-
everybody. And but she was fearing for her death, because for her life, for this reason. On the same day, the hospital authorities also took care and treated. They mentioned everything. There was swelling on her eyes. So what exactly happened was, she fears, because she's from Gwalior, the police, everything would be managed, because earlier one CD is there, one incident, how she has suffered, how she was beaten up earlier. That CD I had displayed long back. If the honorable court permits, that CD, that's how a woman's life. She was earlier beaten up and she was squeezed to death. Practically, he was squeezing earlier. This video is there. It is CCTV footages. So this is in her mind. She's once again beaten up here, despite the court order. On that day, she informed the police. And then he threatens her that if you inform the police, etc., there is danger to your life. I will not leave you to go back. I'll keep the child, etc. Therefore, in the evening, after this treatment, then she decides, if he remains here, there is again problem. She is in a desperate position at that stage. And doctor see everything on that day. She goes back. And then the police contact her, and then the police say they take that much time to contact, despite from the hospital intimation going. They don't do anything. Then the police tell her, you send the complaint in writing to us. She emailed immediately everything to the police, informed everything to us. And what our instructing counsel, what they did was, asked her to cool down. And she was saying that this is for danger, take treatment first. The first thing is to take treatment, go to the hospital. Then she was apprehending that there is a danger to her, she cannot remain here. And this, the defense, all this, I don't want to say anything more. Defense is far from truth. Of course, the Honorable 482 court will exercise the jurisdiction, because there is a counter cases, they have stayed it for the stage. It doesn't mean finally the Honorable court said something or the allegations are false. It may be insulting to a woman who has suffered to say that allegations are false at this stage. The thing is that she has suffered. And the photographs, etc., they speak very bad that we have not produced that photos immediately. We could not take the printout of that. And 11th, she has suffered is an aspect, is a truth. She has gone to the hospital immediately after police took time to register because it's her case that no police will do it because it's very influential. And earlier also it has happened, case was not registered. This is the true affairs. So when that is the situation, that she could not comply with this one aspect. Now, my lords, your lords may kindly see, subsequently what happens is series of cases, one after the other, one after the other. One false case is registered against her that she has taken the gold ornaments with her. She has managed to get her FIR registered against her and her father, alleging that she has taken all the gold ornaments. And the allegation is ornaments given to her is shown in the photo. These are only given to her to wear it. And she took away along with the child. Therefore, it amounts to theft. And her father, who is also a chartered accountant, were accused. One day, after all this, they take a fleet of police there. Before the 482 court, they represent that we are going to compromise. Therefore, the interim order is not extended, it is going to be compromised. And they immediately take the police on a Sunday morning. Luckily, on that day, they were not. They wanted to arrest and produce. Arrest. All of the police went there to the apartment. They wanted to arrest him. This is the situation on which she's go there. Then she has to rush and get an order of anticipatory bail. This all after this order of anticipatory bail. She had to obtain an order of anticipatory bail. Then when that criminal case comes up, when the coordinate bench says, what is this false case you have filed? Then again, they will compromise the matter. Again, the matter goes to the mediation. Now the matter is again pending in the mediation. And this, all these problems, how many cases against her? And cases filed here, all of them have now been transferred to by the order of the Honorable Supreme Court. But the Honorable Supreme Court, as we also said, as far as this orders, which this Honorable Court, my Lord, has passed, it will not affect this Honorable Court's order because this Honorable Court made certain arrangements during the period. Now, what they do is they filed a contempt petition again. Contempt petition is pending before the Honorable Division Bench, which sees that the roster. That is pending. Then before the criminal court, again I say, let them comply with this order. And again they approach the Supreme Court. One more, again they approach the Supreme Court on this point. Yesterday, the matter came up before the Honorable Supreme Court without notice. And the prayer in the Supreme Court was, they filed an MA. Prayer in the Supreme Court was to direct to enforce my Lord's order and give directions to her, etc. Same prayer here. That came to be dismissed yesterday after arguing before the yes, Honorable Supreme Court will permit to withdraw when the Honorable Supreme Court says there's no ground. Then we will withdraw. And they are also agitating the same matter before the family court there, before the DV court there. How many proceedings they are initiating? And this is a person where, despite the Honorable Court's order, he beats. And her fear throughout that she is going to be tortured, etc. It has come true. And it's only a person who comes with clean hands, he can only get the orders of the Honorable Court, not in this way. And put to all sorts of sufferance and keep getting the police there. Which child will come out now of the house? The permanent scar in the mind. With all the police force, they go there. For visitation also with the police force. And to arrest her with the police force. They've done it many times. This is on record. Whatever I am submitting, they went there with the police force. Photos are there, videos are there.
Yes, Mr. Arvind.
But we also trying to see the memo on file.
So I'll tell you.
What
What has happened is,
submission of name before Malord said contrary on this.
before going into all that, you were also present when she has come to Bangalore in the chambers, how it went on. Even I never expected that she would agree for this kind of arrangement, because in these kind of differences, no lady would accept to come to Bangalore periodically and say that I'll stay with my in-laws or some other place. And she has accepted for everything. Then coming to this assault and other things, what she's saying, according to her, it happened on 11th. And after some time, the case is registered after 25th or so. But all these things show that on 11th itself or on 12th, she has informed it to the police. And I'm also telling you what has happened. She, on the same day, she called my PS at Dharwad and informed us that she has been beaten and what am I supposed to do? And she asked, what is that? Can it speak to the judge? She asked it. And they said, no, how can you speak to the judge? You have an advocate, engage the advocate, do whatever you want to do, you do it. This has happened in the month of October. That I remember. First of all, I didn't even recollect what it is. Now I am able to connect to that. That day, whatever she said, I couldn't recollect. Yes. One thing is sure, Mr.
I'm not-
No, one more thing is, Mr. Arun Govindaraj, right from day one, your client is very aggressive. That one though, no, you cannot deny that.
The lordships have observed his behavior, we advise him also that he has to be a little calm, he should not be so
Why,
anxious.
why one petition after the one petition after, why the manner in which you are proceeding? No, can the Supreme Court enforce the order of is it an executing court? And that shows the how desperate your client is.
But for 4 months, not spoken to his.
Huh?
His grandparents, his parents are not spoken, not seen the son for the last 4 months.
These are all.
Despite the lordship's order, maybe.
No, that is like in life, no, it is not about only seeing the child. Child doesn't come just like that.
Relationship has to be there with the mother.
And it is a complete package, either for her or for your client. So don't always, harp on your rights.
No, before you.
And there is a way to deal with it.
Actually,
If somebody, I'll tell you, even if the lady is wrong, there is a way to deal with it.
Yes.
Not this is the way. And she could have said something else. But why? No, what is this medical report? What it says?
Lord, we think about two things. The settlement, Lord, before the criminal petition filed by the wife, Lord, blanket submission made before the court was, we're ready for reconciliation, we're ready for divorce. Custody, we're ready for the mother to have. All we want to do is settle this matter amicably. We want visitation, nothing else. Kindly see the order sheet I produced, Lord, with great effort, let's see the memo filed yesterday, Lord, page number 5.
Could your page, petition.
Let's see that concept, let's give an undertaking to the court. Page 5, Lord, the memo I filed yesterday along with the orders of the Honorable Supreme Court and
Page number 5.
Good,
Lord,
Oracle application.
1 minute, 1 minute. Is it on 7-1?
yes, Lord, 4-2, yesterday, I filed the memo yesterday with the orders of the Honorable Supreme Court transfer order.
Okay.
Lord, we have no interest, Lord, in now initially reconciliation, son by being in Bangalore, all that is out of the window now. We want son to be happy, mother to be happy, all we want is access to the child. That is all. We are ready for divorce, Lord, we are ready for custody to be with her. Kindly see page number 5. His lordship vacates the interim order because of the conduct of the mother.
Because of the compromise talks, don't say that.
Kindly see-
Don't make comment about the coordinate bench order. Yeah.
In the petition filed by the mother,
Yes, what is your take on that about the divorce, the settlement, and giving you having the custody of the boy and visitation to him?
Yes, ma'am, I'm okay, but they are not ready for giving any alimony. My husband didn't pay the school fees also, my son, which you had made in the order. That also is not paid.
Please, I want one submission I wish to make to the Honorable Court, my lords. I bow down to my lord's efforts and the valuable time spent and with a great patience being my lords, the Honorable Court, my lords in the chambers and otherwise also. One aspect I have seen, wish to frankly inform the Honorable Court, throughout, they do all sorts of misdeeds and torture to her. And then when it comes to something, they'll say we'll compromise. And this itself is used to harass her. Continuously it's being done, continuously. In the criminal court also we'll compromise. Then they take the police. They do everything. We are for compromise. That's what I said. We are for compromise. We'll tell her to comply with the order everywhere. It's my duty to inform the client to comply with the order. Despite her, all these grievances and sufferings she is beaten up. That's because there is an order of this Honorable Court. Am I wrong in saying that? To the other court I said, yes, we will direct her to comply with. And despite that, we have done best efforts because it's our duty to comply with the orders. But I cannot be harassed like this, filing one contempt petition there, going to on the Supreme Court before the coordinate bench where there is another criminal case. They are also saying
It is like that.
Please,
Whoever is at fault,
please,
there is an order, and you have any grievance.
please, please,
And at an earliest point of time, she
Please.
should have come before this court.
Please.
And she should have filed this application modification.
bow down.
Court would have considered all these aspects.
Please, please.
The remedy for the litigant is not to, getting away or escaping from the problem.
No, one actual problem was this, my lords. She was insisting that to be filed. Then we said, my lords, that the Honorable Court is sitting there. We cannot, I believe in this, for matrimonial matters, we should minimize the litigation. Is my, I may be wrong.
No,
Maybe I
minimize
may be
the
wrong as far as possible.
Minimize the litigation.
Please, please.
And at the same time, there should be a quietness to it.
Please,
That's the way
please.
we minimize it. Not
Please.
like, just because not by filing a petition and getting both the parties, feeling the burnt of it is not
that's true.
minimizing
That's-
not
that's-
that way.
That's true.
No.
But
no,
this fact, my lords, on affidavit, it was filed to the Honorable Supreme
no,
Court
it
because
is like this.
transfer was pending at that stage, my lords.
It is like this.
Please, please,
No,
I vote on, I agree.
Without going into any of
Please,
the,
please, please.
any of the allegations made
No,
by
no,
her.
they're discussing there again. For this, the coordinate bench, we said, yes, let the matter go on. Now they have appointed an advocate of this bar, my lords, and he is discussing with both the parties. Because the moment, my lords, she says this is the alimony, they laugh at her. This is how do you claim this? So he is discussing now. The alimony part, the learned mediator.
So Govinda, how your client wants to settle it? You said that he wanted divorce. Divorce comes, no. Divorce, first of all, we're talking about the divorce. Divorce comes with go, you will get, anybody, he'll get divorce or he'll give divorce with alimony. With alimony. Without alimony, how it is?
Alimony also section 25 alone speaks of conduct. Entitlement to alimony is based on conduct. I will also, I'll advise.
No, again, we go to that. No.
Claim will not be exorbitant.
No, again, when we go to that, conduct of either of the parties will be considered by the court.
I'm sorry, I'm not into the merits of that. There has to be some reasonable.
What is that she's asking? What is that he is coming forward?
His thing is, my son is taken away from me, I don't want to give it. That's the stance he has taken, it's an extreme stance, I will talk to him. I will talk to him about some payment.
No, it is like, client is not a small boy or like his son.
I will at least.
We don't have to tell them. They have to understand what's good and what is right.
That was it's
And
not
if they don't, they will face the consequences.
not to pay some, but the child, for months, I have not seen the child. But if the effort was really.
No, I'm sorry.
Sir,
We will not. I not seen the child yesterday. 1 minute. Not seen the child. Day before last week, Honorable Coordinate bench said go and visit, and he has visited. Let us not make false submissions. Visited. Then why can you say that? We cannot mislead the Honorable Court. I'm shocked. This way of submissions are being, because we have over duty. Before the court order, he was in the hotel. CCTV footage 2 weeks ago. Kindly permit me. I can get the date. When was that? He visited pursuant to the court order in the hotel.
In second week of January.
Yes, visited in the hotel and not seen child 4 months. This, how can this submission be made? Then no, we cannot. We cannot make this.
His lordship directed that they will comply with the order. Thereafter, until they're going to walk there 4 times and come back empty-handed. Look, that's my son. She locks the house and goes away. But if my learned friend wants to argue on merits, that's a different aspect. Your lordship have asked me about alimony, I will advise him to pay alimony. All we want is access to the child.
It will happen. It will happen. Eventually, it will happen.
But the car you're watching, remember, there's a Mercedes car. I'm paying EMI. There are 2 EMIs. I have found a buyer.
So why did you not sign it?
I produced a document.
Madam, again, they are telling me to come to Bangalore. When I talked to HDFC guys, they said it can be done from Gwalior. I cannot come back to Bangalore for 1 day also. I'm very scared.
What's the problem? She said she's ready, but she cannot.
Bank loan is taken, the bank is asking.
No, ma'am.
Not you.
Bank is not asking.
Somebody is asking her and she has her own difficulty to come to Bangalore at this point of time. No, if you make any alternative arrangement where some authorization or something, or you can do it, she will do it. No, we can't
Yes,
compel
madam.
them under the circumstances.
Because they say you're not the borrower.
No, let him make arrangements for to send the papers, she will sign. And accordingly, he can make arrangements.
Papers are sent to her 5 days.
Papers, sir?
For signature, papers are sent to her 5 days ago.
And she don't have to come.
She's talking to the car, the buyer of the car.
No. She don't have to come to Bangalore.
The car transfer forms have to be signed by her.
That also can be sent.
If she undertakes
No, if the forms are sent to you.
Yes,
you have
madam.
to sign it
Yes, I will.
Do
I
it.
will.
Yes.
So this weekend is the second Saturday. Again, one of the visitation is there. January, she had let.
No, Mr. Govindra, this is not in that manner, we cannot pass any orders. So looking at the gravity of the things that are going on, let there be a settlement and let there be as per the new settlement, things will go on.
There's an order passed by coordinate bench, directing both parties to comply with your lordship's order. Well, referring them to mediation.
No, you have filed a modification petition, then now I'll pass some other order now.
But the request is, Kindly permit me to ask this, my lord, my son. my lord,
It's
was very
okay,
happy.
1 week, if he doesn't go, nothing is going to happen.
I went last month.
Oh, like, with all these things that are happening and how in this kind of environment, what is that he'll do with the
Son was
child?
very happy to see me. Son was very, in fact, she came to the same hotel along with the son.
Let him have a video call every day. We'll ask her to do it. We'll ask her to let him have a video call every day. Yes, let him talk to the son on video call.
Okay, madam. I will do that.
And what about the settlement?
So settlement, a mediator has been appointed.
Who is mediating?
So Prashant, senior mediator for mediations.
And what is the stage of it?
3-4 sittings have gone.
He's given the proposal.
Madam, I have given the proposal from my side for last 1 week. They have not replied also. Mediator is also following up on the WhatsApp group. They are not replying.
Hmm?
We are supposed to give our proposal today or tomorrow.
Please give that.
I hope
Please
the
give
meeting
that and complete it as soon as possible. Now, what we'll do is, this petition, I'll just keep it pending this IA. Now I'll record that, that she's going to sign those papers. She's going to sign those papers pertaining to the transfer of the car, and she'll send it back, number one. Number two, the boy, for the time being, for whatever, for the next, we'll have it on, in the month of March. We'll have it in the month of March, and till such time, every day we'll fix some time. Father will have a video call to the son.
And grandparents.
Huh?
Grandparents.
Anybody, for that, let them have that. Not the physical visitation. She has only difficulty to come to Bangalore or he coming to Gwalior. Let him not do either of it. She will not come, let him not go. Every day let them speak to the child. Because in this
time
way, if you
duration, my
push
lord,
the
sir.
things, it is difficult. Yes, Mr. Srinivas.
Please, time duration also you'll not.
That we will ask her.
Please,
We'll ask her.
please.
No, we'll ask her. When is it convenient for a video call?
Madam, we can do 7:30 to 8 o'clock.
8:30.
7:30 to 8 o'clock, madam.
We'll have it 7:30 to 8:30 or 6:30 to 7:30, whichever is convenient to you.
Madam, 1 hour he will not sit. Then again, these people will say we'll file contempt.
He's
Again,
having
they will
every day.
threaten
We'll
me.
let him have it 7:30 to 8, Mr. Govindraj.
He will not sit for 1 hour.
Where is the present application is filed, IA number?
1 IA is filed, my lords, for vacating or
There is
withdrawal
an
order.
order.
2 IAs.
There is
Cost is good. 1 IA by
serial number 25. IA number 1 of 25 is filed, seeking for modification of the order dated 15/7/2024. IA number 2 of 25 is filed, both by.
One by the father and one by the mother.
Yes, IA 2 is by the
IA
wife.
1 of 25 is filed by the father seeking modification of the order dated 15/7/2024. IA number 2 of 25 is filed by the mother for recalling the order dated 15/7/2024. After the order, it is contention of the land council appearing for the father that after the orders were passed by this court, initially the orders were complied and later the mother failed to comply with the order, and it's been from the last 4 months, the son has not, the father and the grandparents could not see the child. Land council and senior council appearing for the mother submits that when she has come on October 11th to Bangalore, as per the orders passed by this court, she has been assaulted by the husband and she had suffered injury to her eye. And also the boy was completely frightened with what has happened. After that, she left to Gwalior, and thereafter the several petitions were filed before this court by both the parties. And now the things as of now, a coordinate bench of this court has referred the matter for mediation, and the parties are appearing before the mediator. The wife had already sent her proposal to the mediator, and it is for the husband to respond on that. Land council it is the contention of the senior council that as there is threat to her life, she cannot come to Bangalore, and the orders of this court, they are not in a position to comply with the orders of the court, as the order needs to be recalled. Land counsel appearing for the father submits that.
The entry mode of criminal case is being stayed by the son.
Land counsel appearing for the fathers submits that. In fact, in the other matter, in the connected matter, there was a coordinate bench has directed the mother to comply with the order passed by this court. Where is that order?
That I myself undertook, my lords, there I said.
Yes, sir. Let me just see.
Page number 5. Page number 5 and page number 6. Sorry, page number 4.
Not page number 5.
Page number.
Hmm? Directed the parties to comply with the order passed by this court. It is submitted that pending consideration of these applications, I just submitted that even as per the order passed by this court, she has to sign the transfer, the transfer forms of the car, which is in her name. And even that was not done by her. It is also submitted that pending consideration of this application, two IAs filed by both the parties, let there be a direction to the mother to comply with the order, and so that the father and the grandparents will get an opportunity to meet the child.
Madam, his school fees and traveling expenses are also not paid by them as
What
per the
about that?
order.
That is also part of the order.
Well, school fee, we're willing to pay. No, she's not given the school fee receipt at all. She sent an email saying.
It is the contention of the senior counsel appearing for the mother, that as per the order passed by this court, the school fees and other expenses are not paid by the father. And it is the contention of the land council appearing for the father that in spite, what is that? She's not giving the particulars.
Or will be directly to the school also.
He
We
should
have
not
no
go to the school is my respectful submission. With this situation, let him not go to the school again, create any problem. Otherwise, we'll forego the fees. If he's online to her, she will pay it. No, not this way. They let not create. Already, child is in fear psychosis.
No.
From that
what
day
does it-
onwards.
No. Whatever is the school that invoice or whatever it is there.
She's not giving it.
You can, no. What is wrong in paying to her so that she in turn will pay?
She lets me know what the school fee. She's not letting me know.
It is stated that they are ready to pay, but those particulars are not known to the father. Pending consideration of this IA number 1 of 25 and IA 2 of 25, considering the respective arguments of the senior counsel appearing for the mother and the counsel appearing for the respondent, not respondent, and counsel appearing for the father, this court is passing the following order. Number 1, the mother shall sign the transfer forms as agreed as per the final order passed by this court, and shall send those documents within 2 days.
2 days, yes, madam.
Within 2 days to the father. Number 2, the mother, by tomorrow, she shall give the particulars of the school fees, and the father within 2 days from there on shall transfer the school fees shall transfer the school fees
Mother.
to the mother's account. Number 3, until further orders, every day between 7:30, that's what she said.
7:30 to 8.
Between 7:30 to 8, the
PM.
father
PM.
and the grandparents can have a video call with the child, with the boy. Let's this matter on 4th of March. In the meantime, as per the order passed for the coordinate bench, both the parties shall cooperate with the mediator and shall proceed with the same.
Yes. Other portion regarding the physical visitation may be
No,
specific.
neither till further orders passed by this court, the father shall not go to Gwalior.
Well,
There's no need for an order.
no. There is a contempt case, my lords. Here lords also cannot go to,
Shall not visit the boy at Gwalior.
and shall not
Go to
precipitate,
Gwalior, go, not to their place.
and
Yes.
shall not precipitate. The contempt petition is again filed before this only got.
Which one,
The
which
contempt petition is pending, contempt case.
Because this, when this court has interfered with this, no, he cannot, in view of the orders.
They also filed a contempt.
In view of the orders passed by this court and pending consideration of this application, both the parties shall not precipitate any of the proceedings on arising out of this order or for compliance of this order.
Obliged.
Most good.
Cell number 26, 27.
But Mr. Arun Govindaraj tried to see that something works
No,
out.
even valuable is the
It's
issue.
not only that, all this, it doesn't, to any normal human being conscious will be, it is something not right. We cannot keep a lady helpless like this.
I wonder like this,
And not that you are physically strong and not that she is a non-local to this place. And in spite of and because the court has passed an order, she has come all the way. There has to be some, if somebody is disagreeing on certain things, there is a manner and a way to disagree. You can't be physical.
Apparently, instructions are very, nothing of this order.
My God, I don't know. We have the video also. I don't know how to say it now. We have the video also.
Of the matter on 28th of November, when we made a request that she's not complying with the order, well, at that time, no Supreme Court, no allegation. is
We have
made.
filed affidavit also.
So the-
That will be,
Unfortunately, nowadays.
affidavit is there on record.
Keep the child away from the other parent. I'm not saying that she's doing it.
It's
I'm
not
saying
good, it's not good, but at the same time, the theory or the approach of the father that I'll have only son because he is my son and I'll behave whatever I want to with the mother is not the right attitude. After all, let her at least not a wife, but
Mother of my child.
no, let her treat her as a fellow human being. Don't treat as a mother of your child also, as a human being, fellow human being. Have some courtesy.
And also one aspect, my lords, maybe may not be in this case, but in every case, what's happening is many cases, what they do is they use because a mother will have till death, she has a affection for the child, attachment child. What they do is they use it and say, I want a child, all these pressures on custody, etc. It's actually genuine in some cases.
No, but the court's experience is otherwise.
Please.
Not in this case. The
In this
court's
case, it's
experience is
otherwise. Please. In this case, my respect submission is, it is used only to see that nothing is paid to her.
Let it be
They don't want to pay anything. Therefore, they use it as a bargaining rod.
settle, Mr. Arun Govindaraj, if something is where it is happening, once after that, after the next state of hearing, we'll again look into that and we'll see like some other, some mechanism is involved so that things will be
Please.
to a quietus.
But he also needs to stay there, he doesn't want to be, he's tired of litigating. He doesn't want to-
Better he tired at the earliest.
But doesn't want to pay. That's the problem, Ega. Grateful.
And even like your client also.
Please.
Let
We
her
have
think
told her.
about it.
No,
And
she has
it's not
suffered.
like,
In fact,
let
I
her-
should not say,
No,
I should
let her not stick to that figure and sit there.
That is true, my
Let there
lords.
be a via media and let both.
In
she
fact,
also wants
I
live
wish to
with
be,
a peace of
as a advocate with the duty, I wish to inform, our team took lot of time, effort to say her, don't end yourself. She wanted to end herself in many times because when the police goes, the team of police go with the father, they're respectable persons. What would anybody do with arrest warrants? All criminal cases are registered. You'll also kindly see, if I have influence, it doesn't mean that I can use it against my wife. Also the FIR against the wife and with the police the word to arrest. Can it be denied? They went to arrest. Yes. What case? What case is there? Nothing. DV Act has filed for protection. What case? 498 should not file.
377,
That's
my lord,
all.
against the father-in-law.
So they admit
There's
it.
a limit.
Now the case, they have filed it for this reason.
377
This
against the
cannot, I don't
father-in-law.
want to say anything.
Your lordship, I've interacted with the father-in-law.
No, either ways, neither the wife nor the husband are not supposed to do. This is very, very, very alarming and very unfortunate. Yes, call the next.
Cell number 26, 27
Thank
adjourned.
you,
Cell number
madam.
28, VP Kulkarni for petitioner. DC Jagdish.
Huh?
Yes,
Petty?
it's on page 3.
Morning it is adjourned. They didn't inform? That's what, huh? You're also not informed? I made it, that's what, like when the court insists, the court will not adjourn, then whoever is mentioning are feeling bad. No, you have to wait from morning, otherwise you would have gone. So that's the court insists for that and makes a note that you can't without informing the other side, you can't do it. Very unfortunate. When is the date? Have you given the date? Yes. Yes, next.
Cell number 28, VP Kulkarni for petitioner.
Yes.
C. Jagdish.
No, before that, what we will do is, we'll go to the impugned order and then you can see.
Then somebody has started putting up construction inside. Thinking that one Mr. Kumar is constructing this one, he files a suit, 163 up to 78 for bail in it. In that suit.
You're the plaintiff?
I'm the plaintiff. Then my lord, the India suit, ethical finding is given, that my lord, Kumar is not constructing building, the defendant in present suit, Mr. Manjunath is constructing. The suit has the vigilance mark. Subsequently, my lord, in that case, a commissioner was appointed to measure the property and submit a report. And the commissioner has submitted a report in that case, and holding in that Mr. Manjunath is constructed building and he is residing in that building, that report is filed. My lord, I reduced the evidence, I examined the commissioner who was appointed in that case as my witness. My lord, the suggestion was made in this one, and no notice was issued to the my lord, this gentleman, nor he is a party. And the suggestion also made that he is not residing in the and hence my lord, my client felt that appointment of a commissioner is necessary since he was not a party to proceeding. No notice was issued to him and the property was measured in that suit.
But that is at your behest it is done. At your behest you have appointed or examined the advocate commissioner.
Yes. Dismiss my application for appointment of commissioner.
No. You wanted the earlier advocate commissioner to be, you were the plaintiff in the earlier and the present suit.
I mean, my commissioner who has submitted report.
Yes.
And my one of witnesses.
Correct.
Cross examination can come in on the record saying that no notice was issued to the my lord, the present defendant who is that suit. And my lord, he not a party.
He says that report cannot be considered.
That's the objection statement filed before this. And hence, my lord.
Let's see.
Then my lord, the second ground is the application has been filed at the latest stage. My lord, usually the application for appointment of commissioner is filed after the conclusion of an evidence. My lord, after conclusion of the evidence, I filed an application. These are the two grounds of my lord.
Please come to the order.
I will rely on the field order.
Come to page 51.
Yeah.
Come to the reasoning part.
Page number 53. I have gone through the entire material available on record. No doubt plaintiff has filed a suit seeking for release or declaration and mandatory injunction in regards to property. It is not in this suit. That earlier suit by the plaintiff, that is notice number 160/2008. Court commissioner was appointed, he has submitted a report. The court commissioner has already examined plaintiff as to he is cross-examined by the relevant defendant. Sufficient material produced by both the parties to discuss this. Hence my opinion again. One more commissioner cannot be appointed to make the same property, no purpose in serve. Hence the argument of the non-control defendant is acceptable. Now the case is posted for argument. Hence the above point is answered.
No, please come to that objections filed by them. Or their case that because earlier commissioner, that evidence cannot be considered. Where did they say so?
My lord, they try to take my lord objection. Yes, that time will be.
Page number?
the page number 47. You of the minority, only says the minority, you of the minority evidence letter by the commissioner who has submitted the report, no ground in order to get and. But in a cross examination, they put a suggestion saying that I may not, no notice has been issued, no notice has been issued to the minority, the plaintiff, and the minority, underlander who is the minority, one of the side. In absence of this, without issuing notice, minority, the commissioner report that.
No, that particular evidence of the defendant saying that the earlier court commissioner, he was not, he was not put on notice. Where do you get that?
Suggestion and report, my lord, whether they have issued a notice to this one. Court commissioner says, notice has been issued to the plaintiff and the minority, the owner of the site number 16. That is the answer which has been given by the court.
So here also in the objections, they are not denying the earlier commission's report.
He is not denying. Admittedly, no notice has been issued to him. Admittedly, he is not a party to the proceeding.
No, it is never his objection.
No, my lord, whatever objection, fact remains is, he was not a party to the proceeding. And no notice has been issued to him at the time of majority property, it has come in the.
No, when the advocate commissioner is examined and there was a lot, there are so many occasions for him, unless and until there is a pleading or unless and until it is his case that the earlier commissioner's report is not binding or I was not a party, this should have been his case. Without his case, you cannot assume it that he might come up with because he cannot without raising such a ground, without a pleading. How can he subsequently contend that? What did he say in the court?
Answer is, madam, notice has been issued to the minority and to the owner of the site number 16.
No, did anywhere he said that commissioner's report cannot be considered as I was not a party to those to those.
The principle naturally requires, at least at the time of the measuring the property.
Then in that case, you could have done it earlier also. You could have done it earlier also. No, in your case, you are very much relying on the earlier commission's report. And you are also aware that notice is not served on him. No, why did you put a question to him that whether notice is served on you or not? No, I can understand if they come up with that kind of. No, have they cross-examined your client saying that have you put the defendant on notice? So you were only creating that plot for you to file an application. Now, what interest of your client will be protected? Suit of 2016, bare injunction.
Declaration, injunction and possession.
And your suit is and it is stayed by this court?
Before the final hearing. And 23 matter is listed in my note today, last week. I have been trying to get it disposal as of now. He has constructed a building, he is fighting on my property.
So the moral of the story is, for all these kind of applications, you shouldn't come to the High Court. So that your suit itself will be disposed of at the earliest. Yes. Anyhow, what do you say on the merits of the matter? What do you say on the merits of the matter?
He has measure and all the site, in the layout, there will come side of one. That's the only one thing with Madama.
So you have no, you are not, as far as the report of the earlier commission is concerned, the defendant has no dispute on that. Is it so? Shall I record that? No, shall I record that? Huh? No, I'm saying, when counsel appearing for the defendant submits that already the advocate commissioner was appointed earlier, he has submitted the, whoever it is, the commission was appointed and the entire report is before the court. And the court can, basing on that report, court can pass orders. No fresh commissioner needs to be appointed. Is it your stand? Let's see again your objections, page number. Page number 40.
She having acquired the same under the registered credit, so and so. Whether it is true that some Madama had applied for to the deputy commissioner, for grant necessary permission to.
Please come. Agreed with the order. Passed on number 6, it's number 96 of 2016, dated. What is the date? 29? 28/5/2019. The plaintiff is before this court. The plaintiff herein has filed a suit for injunction. In that, he filed an application for appointment of the he has filed an application under Order 26/9, read with Section 151 CPC, seeking for appointment of CDA engineer Chikmagalur as a court commissioner to measure and demarcate the properties in dispute between the plaintiff and the defendants. The petition herein has filed a suit for declaration and permanent injunction. Before this suit, declaration, decree of possession and mandatory injunction. Before this suit, he has filed another suit for injunction against one Kumar, stating that he is interfering with the plaintiff's peaceful possession and enjoyment of the property. In that case, a commissioner was appointed and a report was placed before the court stating that it is not Kumar who has made constructions, but it is the defendant in the present suit who has made constructions and living in that. Then the court had impleaded. Then the present suit came to be filed. After at what stage you filed this application? When the matter was listed for arguments, the present application came to be filed. It is a case of the plaintiff that a commissioner needs to be appointed, as in the earlier suit, the defendant is not a party and no notice is served on him while conducting the survey. The defendant had filed his objections. It is a specific case of the defendant that already the report of the advocate commissioner is on record. It is marked as an exhibit. He has been commissioner, it's already the commissioner attached to the CUDA, Chikmagalur, had visited the site and has submitted his report. And he has been examined in this suit. It is a case of the defendant that when once the commissioner's report is on record, and when once the commissioner is examined, the appointment of this application appointment of CDA engineer Chikmagalur as a court commissioner is not necessary and only to protract the proceedings, the present application is filed. The trial court, by order impugned, had dismissed the said application. The court, while dismissing the application, observes that the earlier court commissioner was examined by the plaintiff as PW2. He is cross-examined by the counsel for the defendants. Sufficient materials are produced by both the parties for disposal of the case. Hence, again, one more commissioner cannot be appointed to measure the property, as no purpose will be served. And accordingly dismiss the petition. Learned counsel appearing for the petitioner plaintiff submits that during the course of cross-examination, it is elicited that the defendant was not put on notice. If on this ground, the advocate commissioner, if they have advanced documents stating that the advocates commissioner's report is not binding on them, as before conducting the survey, no notice is given to the defendant. And at that stage, if the report is not considered, it would cause a lot of prejudice to the case of the plaintiff. As such, they filed this application. He submits that the application is not at a belated stage. Once the evidence is completed and the matter is posted for argument, at that point of time, this application is filed. The court, without considering all these aspects, had dismissed the petition. Next part, learned counsel appearing for the respondent defendant has reiterated the grounds that are taken in the objection petition, and he submits that the court had rightly dismissed the application filed by the plaintiff for appointment of the commissioner. Next para. And he submits that no grounds are made out seeking interference with the well-considered order passed by the trial court. Next para. Having heard the counsels on either side, there is a material on record. In respect of the very same suit scheduled property, an advocate commissioner was appointed in the earlier suit, as the defendant in the said suit was not the one who made the construction, but the respondent herein. As such, the plaintiff has come up with the present suit. And in that, he has marked the commissioner's report, and he has examined the commissioner. And on that, the defendants have not raised any objection stating that the said commissioner's report cannot be considered, as they were not parties to the earlier suit. Even in the objection that are filed also, it is a consistent case that already the advocate commissioner is appointed, and the commissioner's report is marked as an exhibit. And for what purpose? Again, another commissioner needs to be appointed. And according to them, there is no purpose for appointment of another commissioner in these facts and circumstances. The reason what is stated and the assumption of the plaintiff is without any basis, and in the considered opinion of the court, the trial court had rightly dealt with and dismissed the petition. This court finds no reasons to interfere. No, I said that's what I've recorded. So there cannot be such kind of a positive direction. No, I said that's what is his case. He never denied that. I said so, that they have not disputed. That is your assumption. That's what I said. They have not disputed at any place. And in fact, they are accepting in their objection. That's what I recorded. I look into that. Yes. Same common observation. Any of the observations made by this court shall not be construed as an expression of the court. They're all made for the purpose of disposing of this petition, and the court shall independently decide the case. Yes, next.
Cell number 29, Abhinay Vaiti for petitioner.
My lord, I appear for respondents 1 to 4 and 9, my lord.
He was asking for time in the morning.
Please, ma'am.
Let's just matter the request to plan counsel the petitioner on 5th of March.
My lord, one more submission I would like to make, my lord. My lord, the LCR has been called for. My lord, most of those documents, my lord, are in Kannada language. My lord, they may have to supply translated copies also, my lord.
By that time, by 5th of March, it won't be required.
Please.
This is matter on 5th of March.
Yes.
Tomorrow earlier granted is extended till then.
Cell number 30. Karnataka P for petitioner. Tarma Shetty.
Stays there. Stays there. No, is there any stay in this petition? Then list is matter, the request of land council, the petitioner on 17th of March.
Note serial number 31 appear for the petitioner, my lords. Notes in this case, notes the executing court permitted the objector to lead evidence. Your lordship wanted to ascertain whether any order was passed on the objector application. Notes, I've learned that the executing court has passed the order on the objector application, rejecting its application on 7/2/2024. 7/2/2024, not the objector application is rejected. Therefore, not the petition will not.
Please come physically tomorrow.
Yes, notes.
Tomorrow with that order.
Yes, notes. My colleague, in fact, was present there, notes. I will.
He is not here right now.
Please,
Tomorrow
notes.
we'll
Please,
have.
notes.
This is matter tomorrow, the request of plan council, the petitioner 32.
Cell number 32.
Tomorrow, not tomorrow, or day after. Tomorrow more matters are there. Day after.
Please, notes.
Day after.
Please, notes.
Cell number 32. Nagarajati. Vish Sharat Kumar.
Order? Oh. You are the plaintiff. Defendant. What is the suit for? When did you file your written statement? Suit is of which year? Written statement was filed on? And when is this order 6/17 petition? 14/6/2019. What is that you want to plead now, want to amend? Page number? So what we'll do is, we'll go to your affidavit. We'll go to your affidavit in support of IA. Good. So order 6/17 petition is filed by the plaintiff. And for that you have filed his objection, but the court has allowed it. So please come to the imperial. Small order will read from 47, yes. So please come to the plaint now. Original plaint. No, what is amendment is seeking? He mentioned the extent also, 3 acre 10 gundas. I'm looking at the schedule only. Yes. What is amendment you sought?
Scheduled in the original thing. So we want to add few more properties which were not part of the original.
No, what we do is, let's see the plaint. Not amended plaint, the original plaint. What is this case? Correct. Now, why you want to amend it is the question. Let's read the original plaint para 2. The plaintiff submits that, please read. Yes. So, Mr. Counsel, for the respondent, no, according to him, he has purchased these 3 properties by way of 3 sale deeds, and there is an interference from the defendant. No, just like that, your schedule is very important. How can you change the schedule just like that? Correct. No, you have right from the beginning mentioned that in respect of this, you are asking for the relief. So how can that be changed now? No, please show the court what is amended plaint and what is this plaint. No, consciously you have taken it as 13 guntas and 17 guntas is the mandatory injunction you are seeking.
And when in my hands, if they are granted some trees, and the extent what has been enclosed, given there is survey, to the extent, only to that extent I am asking for the minimum, I am not getting land of trees. When they deny the right to the entire thing, I have included the schedule. The prayer, the plain have said that I am the owner of trees, it is not an issue. Even they don't dispute it. It's only the overlapping, they say that ancestors are given to them, but we have got registered status, as per the registered status.
Suit for mandatory injunction. No, this extent you have changed now. That's what I want to see. Where is the amended plaint? Page? No, amended plaint is starts from 19. Let us look at the schedule. What is that you're mentioning? The plaintiff prays for a judgment and decree in his favor against the defendants. Declaration of title. The landed property retained by the defendant number 1 and 2. Initially, you wanted a declaration in respect of 13 guntas, 15 guntas. No, you're seeking a declaration in respect of 3 acres and 10 guntas. No, you sought, no, the plaintiff, you sought an amendment from injunction to declaration. Hmm? Then, why you suddenly realize that? Correct. Suddenly, how you realize that when it was only for 10 guntas and 30 guntas, now it has become for the entire extent of 3 acres, 10 guntas. No, we'll go to straight to your schedule amended plan 26. Now, please come to that. No, come to page 26. That is your amended copy of the plaint. Page number 26. No, that we will go. Please come to page 26. Mention.
No, the confusion is, they also claim 10 guntas and 1 acre 10 guntas. The total extent is 5 acre 26. All the cities are put together.
You are seeking declaration in respect of the plain schedule properties. Initially, you said it is 10 guntas, 13 guntas. Later, you included, you want a declaration for 3 acres so and so, 1 acre, 17 guntas. Is it not? What about 1 acre, 37 guntas?
3 acre 10 guntas includes 1 acre 11 guntas.
So why did you not say that 3 acres, 10 guntas and the earliest for in the first pleadings? That you have said, what you might be having 100 acres of land, but you sought consciously, you have sought for declaration in respect of a small extent of land. And after 7 years, you seek amendment. Why it should be allowed? Yes.
Without any detail of right or ever in motion, they prove for next month. Thank you. The next page, the defendants in person, the reasons and rights and authority to respond to this and in granting the mango plan. When the defendants are prepared the position as the first time claiming their rights, there is a portion of the land which they have granted belongs to them, and even the plaintiff gets survey, the two shall be not enclosed. If it is found that the then only defendants agree to deliver all the law rights and no support in the way submitted the petition to the survey department and on the several of the survey department and you notice defendant goes on 11/1/2011.
You specifically mention about 13 guntas and 17 guntas. Hmm. I don't understand that. If, if, no, you want declaration and mandatory injunction. Mandatory injunction you have mentioned. And also for that, you said declaration in respect of the very same land you asked. Now you have, now you have added everything. Why you didn't do it at the earliest point of time? Your application itself is so as vague as possible. And the order of the court is all the more vague. We'll set aside this order. You can't do it at that, at after so much, after such long delay. The agreed with the orders passed on IN number 14, dated 31/5. What is the date? 14/6. No, it says something like 31/5/2019. 13/1/5/2019. The defendant is before this court. The respondent herein, who is a plaintiff in the suit, had originally filed the suit for declaration that he is the absolute owner of the suit scheduled properties, directing the defendant number 1 and 2, who have illegally entered into the possession and remained in possession since 2/4/2010 to deliver the vacant possession. Further, directing defendant number 3 and 4, who have illegally entered into the possession and remained in possession since 2/4/2010 to deliver the vacant possession of the suit schedule, item number 2, to the plaintiff. He has sought for a mandatory injunction and he has sought for the mandatory injunction and also the possession in respect of plaint 1 and 2 scheduled properties, and he sought for declaration in respect of both the properties. Initially, the suit scheduled properties are survey number 36/1, measuring 13 guntas out of 3.10 guntas, and item number 1A is 36.1, measuring 1 acre 37 guntas. Huh? Page 16. In the original schedule, delete all that about the schedule. The survey number 36/1, measuring 13 guntas out of 3 acre 10 guntas. And the suit schedule, the number 2 is survey number 36/1, measuring 17 guntas out of 3 acre 10 guntas. And the suit is of the year 2013. And on 14/6/2019, this application came to be filed, seeking amendment whereby they want to amend the schedule as for item number 1, it is No, the difference is in second one. Wherein they have to, wherein they, now they have incorporated 1.37 acres. And item number 3 is already there as the 0.03. Earlier also it is there. Or it is not there. It is also added 0. Item number C, that is 0.03 quotas. And that's it. No, they have added 1A and 1C. 1A and 1C were added, where they've shown 1.37 acres and 0.03 quintas. It is stated that they have purchased the property by way of 3 sale deeds. And originally, though they have mentioned about the sale deeds, but the entire land was not mentioned. And now by way of this amendment, they want to incorporate the entire lands in the schedule of the properties. The court by order impugned had allowed that application filed by the plaintiff. While allowing the application, the court gives a finding that by way of the proposed abandonment, the court observes that it is contended by the plaintiff that he has purchased whose scheduled property under 3 registered sale deeds, and total extent of the property was not mentioned in the plaint at the time of filing the suit. And as such, proposed amendment is necessary in order to ascertain the total extent and boundaries of the suit scheduled properties. The proposed amendment will assist the court in ascertaining and elucidating real dispute between the parties. A rejection of the application may lead to multiplicity of proceedings and accordingly allowed the application. Learned counsel appearing for the petitioner defendant submits that when the suit is filed in the year 2013 and the present application is filed in the year 2019 after the commencement of the trial, the court has not even, neither the plaintiff has stated why they have sought for such an amendment now. And there is no observation or there is no reasoning given by the court why such an application is allowed, except stating that it would help the court in ascertaining the real dispute between the parties. He submits that of the amendment to Order 6 Rule 17, unless and until the plaintiff submits before the parties submits before the court that in spite of the due diligence, the pleadings could not be brought to the notice of the court. And in just like that, mechanically, courts cannot entertain the applications, and the order impugned needs to be set aside. Next parallel, counsel appearing for the respondent plaintiff submits that court has rightly passed an order observing that for deciding in the real dispute between the parties, the amendment is necessary. It is submitted that no prejudice would be caused to the defendant. Next, having heard the counsels on either side, there is a material on record. The suit is for declaration of title and mandatory injunction. He is seeking declaration of title in respect of the suit scheduled properties and a mandatory injunction in respect of plaint 1 and 2 scheduled properties. Now, by virtue of the amendment, he has added plaint 1, B and C properties which were not part of his original prayer. Why those properties were not initially added? And now at this point of time, he is seeking declaration of title in respect of the additional properties. There should have been some explanation forthcoming in the application filed by the plaintiff, which is, and a perusal of the affidavit discloses that no such explanation is forthcoming. The court, in a mechanical manner, had allowed this application seeking amendment. The amendment will definitely change the nature of the suit. And the plaintiff cannot be permitted to amend the pleadings at this stage without a proper reason. And in the considered opinion of this court, the order impugned is liable to be set aside. Accordingly, this court is passing the following order. The order passed in I number so-and-so, in OS number so-and-so is set aside. And consequently, I number so-and-so filed by the plaintiff is dismissed.
Case number 33 adjourned. 34, Vikas M for petitioner, Vipin Hegde for respondent.
Not in issue that I owe them money, madam. I mean, the challenge the original order of the finality. With so far as the quantum of amount is concerned, I think I'm not challenging or that is actually finality. The hard question here might not work. They made an execution proceeding. The execution proceeding is not two prayers. One prayer, my lord, for attachment of properties. Second, my lord, was sending it to civil prison, my lord. My lord, several of my properties have already been attached, my lord. When that disposal is yet, before that, my lord, the original property which was mortgaged, that has been sold and that amount has been adjusted to the principal amount. But because the interest is so high, my lord, though the principal was 64 lakhs, my lord, now according to them also the after interest calculation is 48 crores. 64 lakhs is the principal, 48 crores is the amount according to them.
When did you borrow? When did you borrow?
I borrowed in the year 1988, my lord. Degree was passed in the year 2005. Execution proceedings were filed in the year 2011. So that interest calculation is continued, my lord.
So right from 2019, some more interest might have been added now.
It is not the case of the KSFC or the court, my lord. That there are properties which I have deliberately taken from the court or from the KSFC. It is neither their case, my lord, that I have.
What do you say?
Yes. Subsequently, after identification of properties, I got transferred to Mangalore. After the execution. It is something that some of the properties have been mortgaged to the other bank. They are not, we have not only properties. And they are some.
No, for sending him to the civil prison, what are the reasons recorded? There should be some reason for that. Come to the impugned order.
Start from page number 9. From page number 12, the reasoning starts. Start reading from the second and number 5. So in case of the KSFC, that respondent number 1 has availed a loan of rupees 90 lakhs on 14/1/1999 for the purpose of development of its industry is concerned on the guarantee offered by respondent number 225. The said petition came to be allowed on 9/3/2005, wherein it was held that respondent number 225 are jointly and severally liable to pay a sum of rupees 1,66,83,750 to KSFC along with interest at the rate of 19% per annum on rupees 1,32,016, 1,32,16,000 at the rate of 20.5% per annum on the amount of rupees 34,67,309 compounded quarterly basis of 10/9/2002 in date of realization. Subsequently, KSFC filed an execution petition before the additional district judge at Shivamogga, the execution petition 78/2011, and sought transfer of decree to the district court Bangalore on the ground that judgment entered possesses immovable properties within the jurisdiction of this court. Accordingly, KSFC filed the execution petition on 21/9/2011. Pursuant to say, show cause notices were issued to the judgment letter. On service of such notices, judgment letter 2 and 3 appeared before the court through their counsel on 16/12/2011. However, the judgment letter 1 did not appear before the court in spite of notice published against the subject of the record. After KSFC sought an order of attachment in respect of immovable properties belonging to judgment letter 2, when KSFC took steps to bring properties for court sale, while Diane appeared before the court through this counsel filed an application for order 21/258 of CPC, raising his objection
for sale of those properties. The court posted for inquiry on such application, that is IA number 4. The obstructor failed to appear before the court and to accuse his evidence in support of this contention. At that time, that is on 10/2/2016, counsel for the obstructor retired from the case on the ground of no instruction. As such application came to be dismissed on 10/2/2016. At that stage, KSFC proceeding, that is on 16/11/2016, KSFC came up with an application under that IA number 6 under order 60, section 16, order 21, rule 64 and 62 PPC, praying to attach.
Where is the show cause notice and where is your reply to that? Where is your reply to the show cause notice? Court has, you must have appeared before the court and file your objections. No, come to page number 11.
Yes.
Not page number 11, page number 15.
Yes.
Para number 8. End of para number 8. Where are your objections? File.
Yes.
Then counsel the petitioner submits that. We'll come up, we'll file objections, which are filed before the trial court. This is matter on 4th March. Yes, next.
Number 35.
Interboard,
Sampati.
look at it if it is there extra. Thirty?
35.
You have an interim order. This is matter on 18th of March. Interim order earlier granted is extended till then. Yes, next.
Till number 36, urgent, 37. Nagesh BS for petitioner.
No representation on behalf of either of the parties. This is matter on 8th April.
Till number 38, urgent. Till number 39. Jeka Shetty. 38, 39, Jeka Shetty. Not even.
39, no representation.
He is representing.
38 is over.
39 minutes.
Yes, 39, what do you want? Interim order? Who wants time?
I thought 38 is mine. 39 is mine. I'm appearing for
Correct, 39, argue the matter I'm saying. Why? Yes. This is matter on 11th of March. Interim order earlier granted is extended till then. It's 40.
Till number 40. Till number 40, Praveen Kumar. KL. For petitioner,
You're ready?
K.A. Ariga.
Huh? The interim order is there,
In the last occasion, it is not extended.
extended, then no representation where the petitioner comes for the respondent is present. This is matter on 25th of March. Yes.
Till number 41.
Huh?
This is a simple amendment to clarification.
Yes, okay, we'll grant 2 days on Friday. Friday. At the request of the land counsel for the petitioner seeks time, land counsel for the respondent is ready. This is matter as part heard on Friday. 11th, it is not possible. Either you have it on Friday or it will go on a long date. Friday, this coming Friday on 7th.
7 to day after tomorrow.
This is matter on 10th of March. It won't be like that. How can the order be a the court won't mention like that. Yes. No case will be taken at 3 PM. You can make a request with your colleague. Yes, next. There is not a parted matter. Yes. Yes, yes.
Serial
Next.
number 42, 10-3.
Yes.
Serial number 42, Kalyan R for petitioner.
10th of February, let him know. Yes.
10th of.
Yes.
Serial number 42, Kalyan R for petitioner. R.A. Chandrasekhar.
No representation, this matter on 29th of April.
Serial number 43, Sharath S. Gowda for petitioner.
This is matter on Monday at the request of non-counsel for the petitioner. Yes. Wednesday.
Serial number 43, at the request of non-counsel for the petitioner. 12-2, madam. 42, 29-4. 41, 10-2. ಆಮೇಲೆ 40, 25-3. 25-3. ಆಯ್ತಾ? 39, 11-3 12-3 ನೋಡು. 39, 11-3.
ಇದು ಬರ್ಕೊಡಿ.
ಯಾವ್ದು?
33/3. 34 ಇಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ. 33 ನಿಮ್ಗೆ ಆಗೇ ಇಲ್ಲಲ್ಲ ನಾನು. 33 ಅವ್ರಿಗೆ ಆಗಿರೋದು. BN ಗೆ. ಇದು 33 BN ಗೆ ಆಗಿರೋದು ಇದು. ನಿಮ್ಗೆ 34 ಇಂದ 43. 32 ಈಗ 32 ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ. 32 ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ 33 ಅರ್ಜೆಂಟ್. 34 43. ಸೊ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನೋ ಹೇಳಿದಾರೆ.
43 ಸರಿ.
ಆಮೇಲೆ 35 18-3. ಐವೋ ಇದೆಯಂತೆ ನೋಡಿ ಅಂದ್ರು. ನೋಡಿ. 36 ನಿಮ್ಗಾಗಿಲ್ಲ. 37 8-4. 38 ನಿಮ್ಗಾಗಿಲ್ಲ. ಅದು BN ಗಾಗಿಲ್ಲ. ಆಮೇಲೆ 39 11-3. 40 25-3. 41 10-2. ಆಮೇಲೆ 42 29-4. 43 12-2. ಅಲ್ಲ ಇವ್ರೇನ್ ಅಡ್ವೊಕೇಟ್